आइए सर।
हाँ जी. Sorry to disturb on Saturday, my lords. That's a
नहीं हुआ ना तोरिन भाई. अच्छा कई दिवसीय दलीलो तुम्हारे.
sir. Leave it to honorable court and the subject to the convenience of the court first. This is a longish matter, and of course, certain judgments and those things which across the bar. How can I do that? Only though the lists are there, but there are after filing the petitions, there are 3-4 judgments delivered by honorable Supreme Court directly on the point. It would curtail the time of arguments because law has become settled in my favor. That's my respectful submission. The issue before the court is, of course, transfer of shares, which I have given the brief idea. Of course, that was before 2-3 months. In between, my lords, I have taken or passed several matters. So
Yes.
I have to first of all recapitulate the facts of the case.
Yes.
And then I leave it to honorable court that whether this today it is convenient to honorable court or any other day. I leave it to honorable court.
બસ સમાવાળા ક્યાં છે આવ્યા છે આજે.
જી સર, એ પણ એમનો મને કીધું સર બપોરે રાખ્યું પણ વાંધો નથી. આવતા વર્ષે એ કાઢ્યું કરતા પણ વાંધો નહીં સર, હું બેઠો છું.
તમે કોના તરફથી છો? મિસ્ટર જેવી વર્મા તરફથી છો?
ના સર, જીવી સર.
જેવી શાહ
જેવી વર્મા
અને કેશ પટેલ.
કેશ પટેલ તો નથી આવતા ને? ના, એ સર નથી આવતા. જેવી વર્મા કેશ પટેલ એટલે જેવી સર બપોરે આવે. લાસ્ટ ટાઈમ હું મેન્શન કર્યું બપોરે રાખી સર મેડમ.
Sorindo, if you want to finish your arguments, you can proceed with the arguments.
Yes, I can start the matter.
And as regards citation is concerned, you may give it to your some junior advocate who is present over here.
One colleague is there. I do not know. Because Joshi, Mr. Sunil Joshi is an advocate on record along with me, and there's one. His colleague is there, but he would not able to bring a judgment and give it to honorable court either.
Just give me the citations. You will take out the print from here. We are also having all softwares.
Very good.
It will not be difficult for us to take out the print of the citations which you give to us.
Yes. Lordship may just at this stage, Lordship may start with the matter of the facts of the case. I can show it to those documents on record, and so far as the judgments are concerned, I would give a citation to the.
Yes.
So he would meantime.
We don't need any physical copy of the citations. You just give the.
Very good. Very good.
Print over here.
Very good. Because it's a longish matter. There are so many facts.
Yes. ચલો સોરીનભાઈ તમે સ્ટાર્ટ કરી દો આપણે.
हाँ जी साहब, પછી જે આપની અનુકૂળતા આપને જે લાગે આપણે at least let us start, so one day it can be over. At least brief the litigation is very important for both the parties.
Yes.
So the facts are very documentary facts are there.
Yes.
But there are series of facts and events.
Yes.
Sir, we have filed. Now, let me just give a brief idea. Sir, we have filed the present suit. Kindly see the plaint, sir.
Yes.
Plaint, my lord would find at page 8.
Yes.
And kindly go to the prayer part. first. That is at page 21. Plaint, page 21. Upperni side साहब जे there are two numbers if it is so lordship में just take it up जमनी side top ऊपर जे लख्यो છે એ number साहब आप જોજો
બરાબર છે રાઈટ
તો પછી એટલે confusion ના થાય
બરાબર
the paragraph 19 and then after page 21 prayer declare that my lords have got it
yes yes agreement dated 3
declared agreement dated 3rd March 2006 is valid subsisting and binding upon all the defendants first so declaratory suit direct defendant number 1 to fulfill his obligation under agreement dated 3/3/2006
yes
direct defendant number 1 2 3 transfer the outstanding 3,43,130 shares of defendant 4 company in the name of plaintiff. Then further, direct defendant number 4 to effect the transfer of the outstanding 3,40,130 shares of defendant number 4 company in the name of the plaintiff in its records. Order that defendants be permanently restrained from selling, transferring, alienating, distributing, encumbering, or otherwise dealing with 3,40,000 shares of defendant number 4 company held in the name of defendant number 3 without express consent to the plaintiff. So these are the 5 reliefs. There are 2 reliefs, mainly declaratory suit. First player is to declare that the particular agreement 3/3/2006 is valid.
Yes.
And second, then perform that particular agreement. I would take it to the agreement.
yes
So on 2 counts mainly, that agreement is valid and subsisting, and the number of shares stated in the agreement, that is 3,40,130, as agreed in the agreement, shall be transferred to the plaintiff. That is the prayer.
yes
Sum and substance, overall prayer. I am not going to the each and every prayer at this stage.
okay.
I have filed this being a commercial suit. It was filed at Savli during COVID period. Lordship may kindly say these are the facts would come in play.
yes
It was filed on 9/7/2020
okay
and physical copy was submitted on 6th of August 2020 at page 22. Lordship would find that those things
yes yes
and the affidavit and everything. All right.
yes.
Now, kindly, sir, go to the cause title of the suit. Who are the plaintiff and who are the defendants, and the prayers prayed in what fashion, in what manner. Page 8, the first page of the plaint.
Desai Shares and Stock Private Limited.
Yes, that is the plaintiff. Desai Stock and Service. My lords, may the next page. Who are the defendants? Shikhar Leasing and Trading Limited. This is a defendant number 1.
yes
Second is Anchor Electric Private Limited.
yes
Third is Assort Soft Caps Private Limited.
yes
And the fourth is Bharat Parentals Limited.
yes
Now, if we, Lordship may kindly see page 21, the prayer. What is prayed? That the shares of defendant number 4, that is who is the shares of a defendant number 4, it's a public limited company.
That is Bharat
Parentals.
Parental.
Bharat Parentals has borrowed certain money from defendant number 2 and 3 and enter into an agreement that is 3rd March 2006 with plaintiff, that plaintiff will discharge the obligation of defendant number 4, that the borrowed amount taken by the defendant number 4 from 2 and 3, that amount shall be discharged by the plaintiff on behalf of defendant number 4 at the valued price, and the shares which are in favor of 2 and 3 shall be transferred to the plaintiff. That is the crux of the matter. Now, I would request the agreement which is on record that my lords would find at page 28. Now, this agreement would give all the details, and then I would now, yes, that's very important fact. The overall thing is I have filed this application of a suit during COVID. The other side means the defendant number 3, Asoj, file an application under Order 7, Rule 11 that the suit is barred by law of limitation and there is no cause of action against defendant number 3 only. Upon hearing during COVID, the 711 application was allowed, though the prayer prayed in pleadings and everything in the application of 711 is related to Qua 3, defendant number 3. However, the court below has rejected the plaint under Order 711, stating that the plaint is barred by law of limitation and there is no cause of action. Against that, I have preferred the present appeal. Now, pending the along with the appeal, I have filed an application under.
You have rejected only against number 3.
No, against all. That is a surprising thing, which is the settled law.
Okay.
It cannot. That's very important thing. Application is filed by. I would take it to the my lords. The application below filed under Order 7, Rule 11 by the defendant number 3. All pleadings are against square related to 3. However, the court has said that there is no cause of against anybody, against all the persons. Now, the Honorable Supreme Court, which I would that I was saying that recently, before 6 months, there is a judgment of the Honorable Supreme Court, even though the Sejal Glass case was also cited of the Honorable Supreme Court before the trial court, that it cannot be dismissed in piecemeal. Supposing I have filed, if there is a cause of action in any of the defendants, if the cause of action is subsisting against anybody, the suit cannot be dismissed.
First, let me know about the parties.
Yes.
Is your say that number 4 has borrowed loan from number 2 and 3?
So, Lordship may kindly see page 28. Let us go to the agreement. So, Lordship would be having the exact facts and figures, and because this matter is based on facts. My lords may kindly see what is the agreement and
Agreement at page it is there.
Page 28, my lord.
28, yes, I got
yes,
it.
28.
Yes.
Lordship may kindly see the agreement. I would read the agreement between whom and for which purpose. This agreement is made at Mumbai, 3rd day March 2006, which is I have read in the prayer, the particular date, by and between Shikhar Leasing Trading Limited, having its office situated at so-and-so, that is the defendant number 1.
Yes.
If Shikhar is defendant number 1, call the vendor of one part, and Desai Stock Private Limited, having registered office Vadodara, call purchaser, there is the plaintiff. So there's an agreement between the defendant, between the plaintiff and then defendant number 1.
Number 1, yes.
Now, kindly see the next page, page 29. What's the agreement about? Whereas the vendor and others, this is very important, Lordship may mark. Others. Because at several stages, I would emphasize certain words that my case is that Shikhar, I would come to the point later on, but Lordship may mark others. That's at this stage. Are absolutely.
And others. Whereas the vendors and others.
Others, as per Annexure A, which is a part of the agreement as well. Lordship may kindly see. Are absolutely seize, possess of and hold 29 lakhs 91,096 equity shares of Bharat Parentals Limited. That is the defendant number 4. So the Annexure A ma vendor ane vati annexure A માં, if my lords would find કે 29 લાખ shares vendor અને બીજા પાસેના નામમાં પડેલા છે. Seize, absolutely seize and purchase and hold of so and so shares incorporated so and so. Then the next paragraph. And whereas Bharat Parental Limited, Lordship may kindly see, has borrowed from and has outstanding loans of 53 લાખ 336 અને બીજા
64 lakhs 8,000.
64 lakhs and so as on date due to, kindly see, anchor, that is defend number 2, and assoc soft camps, that is defend number 3. એટલે ભારત પેરેન્ટરે 53 લાખ અને 64 લાખ ડિફેન્ડર નંબર 2, 3 પાસેથી બોરો કરેલા છે. First thing.
Kerala che date is not there. From where?
No, date is not mentioned. It is in past. There is not material thing, but it is admitted fact. There is no dispute about this fact.
Okay.
Next paragraph. And whereas the vendor has agreed to sell aforesaid shares held by them and others, Lordship may kindly see, and others. પહેલા પણ સાહેબ others આવ્યું. And others.
And the vendor, who is the vendor?
Vendor is the Shikhar, defendant number 1.
Defendant number 1, okay.
હા. એટલે મારો કેસ એવો છે સાહેબ કે ડિફેન્ડન્ટ નંબર 1 એ એગ્રીમેન્ટ કર્યો બધા જ વતી જે એનેક્ચર એ છે, કેટલા શેર્સ કે 29 લાખના શેર્સ છે એ શિખરના નામના છે અને બીજા 42 એનેક્ચર એ માં 42 persons છે જે પાર્ટ ઓફ ધી એગ્રીમેન્ટ એના વતી એગ્રીમેન્ટ કરે છે, એના વતી એન્ડ અધર્સ ઓન બિહાફ ઓફ અધર્સ કે ભાઈ આ શેરો તમને આ વેલ્યુ ઉપર તમે મને આટલાટની કન્ડિશન કરો તો અમે તમને પાછા આપી દઈએ. જે એમને આપ્યા નહીં, મેં પેમેન્ટ કરી નાખ્યું, કન્સિડરેશન એમાઉન્ટ આપ્યું, આઈ ડિસ્ચાર્જ ધી ઓબ્લિગેશન ધી બોરોડ એમાઉન્ટ, તે છતાં આપ્યા નહીં એટલે મેં આ દાવો કર્યો. This is the thing. Are sum and substance. Now, on this background, I once again read the paragraph 3. And whereas the vendor has agreed to sell aforesaid shares held by them and others to the purchasers, and purchasers agreed to buy the said shares from the vendor free from any charge and encumbrances for consideration as mutually agreed by and between the parties, and also to arrange for payment of the outstanding loans to the creditors above named to the extent and in the manner stated hereinafter. So, Lordship may kindly see further. So, limitation is not fixed. જેવા હું પેમેન્ટ કરું એટલે એમને મને આપવાના. પછી and whereas a sum of rupees, હવે કેવી રીતે પૈસા આપવાના એનું સાહેબ મોડાલિટીઝ આવે છે. Whereas sum of rupees 8 lakhs being the interest is also agreed to be paid on aforesaid loan amount. જે સાહેબ 56 લાખ ને 64 લાખ ને 53 લાખ ને ડિફેન્ડ નંબર 2 ને આપવાના છે તો એમાં અત્યાર સુધી આપ્યા નહીં, એનું ઇન્ટરેસ્ટ 8 લાખ be paid on aforesaid loan amount of the above named creditors for a period of 12 months commencing from April 2005 up to the March 2006. એનું 8 લાખ રૂપિયા ઇન્ટરેસ્ટ આપવાનું. Next. And whereas the consideration of a sale of aforesaid equity shares being the held by vendor and amount of loan payable to the creditors including interest amount agreed to be 275 lakh, એટલે 2,75 લાખ herein after referred to as the statement of settlement amount. એટલે સાહેબ 2,75 લાખ રૂપિયા કેવી રીતે થાય એ પણ ગણાવો. એ પાછળ આવશે સાહેબ. 53 લાખ અને 64 લાખનું આપણે ટોટલ કરીએ તો 1,25,18,415 થાય.
બરાબર.
અને જે શેર્સની વેલ્યુ જે થાય છે એ 1,50,00,000 થાય છે. એ હજી પાછળ આવશે જ સાહેબ, હજી એગ્રીમેન્ટમાં જ લખેલું છે. પેજ 30. Next, page 30. Now this agreement witness, and it is hereby agreed upon by and between the parties hereto as under. First, that the vendor shall sell and transfer his entire shares held in the capital of Bharat Parentals to the purchaser and their nominees, and the purchaser shall buy from vendor the said shares. So it is an obligation on the vendor side. આ એગ્રીમેન્ટમાં ઓબ્લિગેશન ઓન વેન્ડર મીન્સ ડિફેન્ડ નંબર 1. Next, now obligation on me that the purchaser shall advance unsecured loans if necessary to Bharat Parentals Limited. We shall repay the amount of outstanding loan agreed at rupees 1 crore 25 lakh. મેં સાહેબ પેલું જે ટોટલ કીધું એ આ લોનની અમાઉન્ટ 1 crore 25 થઈ, including amount of interest rupees 8 lakh એમાં આવી ગયા. The purchaser shall pay rupees 20 lakhs TDS on interest to the vendor before so and so towards the loan repayment, and balance repayment of in 12 monthly equivalent of 8,33,000 each commencing from April 2006. So this is an obligation on me. Next, the purchaser shall pay, એટલે મારે શું pay કરવાનું, to the vendor towards purchase of aforesaid shares an amount of rupees 1,50,000 crore in 12 monthly equal installments of rupees 12,50,000 each beginning from April 2006. So સાહેબ એટલે આપ જોશો 1 crore 25 lakh discharge of the પેલું જે લોનની amount ની થઈ અને 1 crore 50 lakh એ shares ની value થઈ. બરાબર છે સાહેબ. હવે આગલા પેજ ઉપર સાહેબ આપણે જોયું પેજ 29 માં 2 crore 75 લાખની છે, એટલે 1 crore ને 25 ને 1 crore સોરી 1 crore 25 ને 1 50 થઈને 2 75 થઈ ગયા. બરાબર છે. Next paragraph, that the vendor shall confirm and acknowledge the receipt of the payment towards the repayment of the loans, interest thereon, and consideration for sale of sales. So it's a continuing wrong. Further, next paragraph. The vendor shall hand over the share certificate consisting of 229 lakhs 91,096 equity shares of Bharat Parental along with duly signed deeds of a transfer to the purchaser on payment of full settlement amount, and these agreements shall be considered formal sale of shares at listed at so and so forming part of this agreement. Next paragraph, sir. Page 31. The post-dated checks given detail in Annexure B forming part of this agreement should be honored as per the schedule of payment given. In event of consecutive 2 defaults on the part of a purchaser is making payment, the amount of rupees 50 lakhs given up from the towards of this agreement would be forfeited by the vendor. So the 50 lakh rupees आई गया છે તો એમને admit કરી દીધું સર. Next paragraph, that till the payment of settlement amount is made in full and vendor shall hold and to continue to hold second charge of a land building. જ્યાં સુધી પૈસા ના આવે ત્યાં સુધી charge રહેશે. That's not important now. Next paragraph, sir. This is most important paragraph. That the sale of shares, my lords are there?
Yes.
That the sale of shares shall be completed only on payment of the full settlement so and so and shall be board of directors. Then lordship may kindly see page 27. Very important part. હવે સાહેબ હવે આવ્યો છે એ લોકોનું cause of action ની વાત જે આવે છે અહીંયા આવે છે. Page 27, page 32. Sorry, page 32 sir. અને signature સાહેબ. હવે party of the first part સાહેબ left hand side આપ જોશો તો જે સહી છે એ party of the first part શિખર લીઝિંગ એન્ડ ટ્રેડિંગ લિમિટેડ ના એટલે વેન્ડર ની સહી છે, ડિફેન્ડ નંબર 1. બરાબર સાહેબ આ સહી છે સાહેબ, ખાલી નામ બહુ ઇમ્પોર્ટન્ટ છે, જાદવજી શાહનું લખવાનું છે નામ. આ જાદવ, there is no dispute about it. અને સાહેબ નીચે સહી છે પાર્ટી ઓફ ધ સેકન્ડ પાર્ટ દેસાઈ શેર સ્ટોક્સ લિમિટેડ ના, એટલે પર્ચેઝર, ધેટ્સ અ પ્લેન્ટિફ. અને કન્ફર્મિંગ પાર્ટી તરીકે નીચે ફોર ભારત પેરેન્ટલ્સ ભારત લિમિટેડ કન્ફર્મિંગ પાર્ટી ડિફેન્ડ નંબર 4. હવે સાહેબ એનેક્સર એ પેજ 33 ઇઝ વેરી ઇમ્પોર્ટન્ટ. જે સાહેબ હવે હું જે અધર્સ બે જગ્યાએ લખેલું છે page 24 page 29 top ઉપર, once again I only read that part and then page 33 વાંચું. આપે page 29 top ઉપર જોયું કે vendors and others as per annexure A એક વસ્તુ, અને એ જ પેજ ઉપર થર્ડ પેરેગ્રાફમાં the whereas the vendor has agreed to sell aforesaid shares held by them and others. Who are these others? At annexure A, page 33. અને સાહેબ page 33 થી તે 36 સુધી
Page 33.
33 to 35 સુધી,
Hmm.
sorry, yes, 36 સુધી આખા 42 જે છે એના લિસ્ટનું નામ છે. 42 માં લિસ્ટનું નામ છે.
They are all others.
All are others.
Hmm.
Now others માં સાહેબ kindly see અસોજ નું નામ આવી જાય છે પેજ 34 ઉપર, સેકન્ડ લાસ્ટ
Hmm.
નેમ લેફ્ટ હેન્ડ સાઈડ આપને જોવા મળશે અસોજ ઓફ કેપ્સ પ્રાઇવેટ લિમિટેડ.
Yes.
અને સાહેબ એની સામે જોશો 3,40,130 શેર્સ ટોપ એ શેરનું કોલમ આવશે અને એમાં 3,40,000 નું કોલમ
Hmm.
અને 6.50 ના શેર્સની વેલ્યુ
6.50.
પૈસા બસ પર શેર 6.50.
As a per share. Okay.
યસ એટલે સાહેબ જો એટલે અસોજ એટલે કહેવાનો મતલબ સાહેબ એવો થયો
Hmm.
કે ધ શિખર
Hmm.
ધ ડિફેન્ડ નંબર 1
Hmm.
being a vendor has signed on behalf of defendant number 3 and 4 and 42 others જે લિસ્ટ આપેલું છે which is part of the agreement, this is part of the agreement, on behalf of others અને agreed to transfer the shares of defendant number 4 in my favor as per this agreement.
The shares of all these defendants are in the custody of this number one, Shikhar Leasing.
ના એટલે સાહેબ બહુ પર્ટિક્યુલર કરે, આઈ એમ ઓબ્લાઇજ્ડ સાહેબ. એટલે એને શું કર્યું આ 42 જે એના જે બધા જ આખું લિસ્ટ છે પેજ 36 there are 42 which is mentioned in the plaint, total 42. એમાં 42 માં ડિફેન્ડ નંબર 3 પણ આવી જાય છે અને એની પાસે આ શેર્સ છે. મારો કેસ એવો છે કે શિખર defend number 2 and 3 are a part of the same group which I have mentioned in the correspondence and in the plaint, part of the same person's agent principal no principal lagaiye and he has signed on behalf of others, so he has agreed. So I have prayed against defendant number 1 because agreement defendant number 1 કર્યું એટલે તમે અગ્રી થયા છો, executed on behalf of all, એટલે you have to hand over these shares upon the receipt of the consideration amount, which now consideration amount which lordship would find on page 37. This is there is a part of exhibit B.
Yes.
અને સાહેબ જોશો
કોણ આમાં સોરીને બીજા લોકો પણ આવે છે તો આપણે એડમિટ કરીએ છીએ બીજાને પણ એડવોકેટ્સ ને.
હા એ તો સાહેબ એ તો કરવા જ પડે. If they are party તો then of course they are party to the probably જયની બેન હશે કે કોઈ હશે એમના એડવોકેટ તરફ.
કરો
બંને છે એક જ છે કે બે છે બંને ઓફિસ બની કે એડવોકેટ છે બે અલગ અલગ છે.
ચલો અમે એડમિટ કરી દો.
તમારો માઇક અનમ્યુટ કરો.
આદિત્ય
યાજ્ઞિક સાહેબ.
કઈ નહીં વાંધો નહીં.
Lordships, we are here. Yes, your lordships, we are here. Yes.
ચલો વાંધો નહીં. હા બોલો આપણે.
એટલે યાજ્ઞિક you are not visible.
I am just entering the courtroom. Give me 5 minutes, sir. You may start, but we are taking notes. I should be joining
Okay,
in.
fair
Please
enough.
feel free, Saurin bhai. Please.
Fair enough.
Yes,
please,
that is
please.
video.
હાજી પેજ 37 સાહેબ જોશો.
હા એમાં એન્કર લીઝિંગ આપણે એન્કર
હા એટલે પેજ 37 પર જોશો તો annexure B1 is also part of this agreement અને સાહેબ એનું હેડિંગ જોશો list of checks of HDFC Bank for payment of loan installments. જે સાહેબ અમારે પૈસા આપવાના હતા લોન પેટે એટલે પેલા એના કોને સાહેબ આ બધા ચેક પેટે બધા પૈસા આપી દીધા 1,40,00,000 એટલે 1,25,00,000 in favor of defend number 2. So we have paid aforesaid amounts. Page 37. Then page 38. એટલે આ લોન એમાઉન્ટ નું પેમેન્ટ થઈ ગયું સાહેબ. પેજ 38 is also part of the agreement. અને સાહેબ કાઇન્ડલી સી હવે પેજ 30 એનું સાહેબ હેડિંગ જુઓ, ટોપ ઉપર ટેબલ છે, લિસ્ટ ઓફ HDFC Bank checks towards the payment of purchases of share of Desai Tech so and so so and so.
By Mrs. Desai shares in.
હા સાહેબ એટલે આ શેરના કન્સિડરેશન એમાઉન્ટ my lords would find the કોના સિરિયલ નંબર, ચેક નંબર, એમાઉન્ટ અને ઇન ફેવર ઓફ. હવે સાહેબ કાઇન્ડલી સી આઇટમ નંબર 4 થી સ્ટાર્ટ કરીએ તો શિખરને પૈસા આપ્યા, પછી 4, 5, 6 શિખરને આપી દીધા પૈસા. સાહેબ વી આર કન્સર્ન વિથ ઇન ધીસ મેટર ઇઝ 7 and 8 એન્કર ઇલેક્ટ્રિકલ પ્રાઇવેટ લિમિટેડ અને એન્કર ઇલેક્ટ્રિકલ પ્રાઇવેટ લિમિટેડ. હવે સાહેબ આ જોશો એમાઉન્ટ તો
એમાઉન્ટ કોણે પેડ કર્યા?
હાજી મેં કર્યા સાહેબ, પ્લેન્ટિફે કર્યા સાહેબ,
ઓકે,
પ્લેન્ટિફે કર્યા. એટલે પ્લેન્ટિફ હેઝ discharged the obligations, paid the amount, so I am entitled for the shares because this is for the purchase of the shares of defendant number 4 company, which I have discharged the obligations. But the checks are amount issued in favor of anchor.
Okay.
That is defendant number 2. હવે સાહેબ આ તમે ટોટલ કરશો તો 17,650,000 થશે. એટલે આની એમાઉન્ટ 1,75,00,000 થાય અને એના શેર્સ ને ગણી નાખો, ભાગી નાખીએ એટલે ટૂંકમાં there is no denial. આમાં આપણે એક્ઝેક્ટ એમાઉન્ટ ટેલી થઈ જશે. એટલે આઈ નોટ
50 લાખ લખેલી છે નીચે.
હા સાહેબ 1,50,00,000 થાય ટોટલ.
બરાબર.
હવે સાહેબ એના નંબર જોશો 44 થશે સાહેબ, જો સિરિયલ નંબર. આ બધાને મેં જુદી જુદી રીતે પૈસા આપ્યા, આખી એમાઉન્ટ. બરાબર છે સાહેબ. એટલે મિનિંગ ધેર બાય. હવે સાહેબ નેક્સ્ટ પેજ ઉપર પેજ 39 સાહેબ આખું લિસ્ટ આ મૂક્યું અને ઇન ધ મિડલમાં સાહેબ ઝીણા અક્ષર છે સોરી, પણ ઇન ધ મિડલમાં લોર્ડશિપ વુડ ફાઇન્ડ અસોજ સોફ્ટ કેપ્સ પ્રાઇવેટ લિમિટેડ અને એની બાજુમાં નેક્સ્ટ એન્કર ગ્રુપ કંપની. સાહેબ ધીસ ઇઝ વેરી મચ ઇમ્પોર્ટન્ટ which goes to the root of the matter.
એન્કર ગ્રુપ કંપની.
એન્કર ગ્રુપ એટલે મારો કેસ એવો છે કે defender number 1, 2 and 3 are part of a group company. I would take it to the pleadings as well. ગ્રુપ કંપની છે અને સાહેબ લાસ્ટ જોશો ફિગર્સ 3,40,000 ની એમાઉન્ટ એટલે પેલા શેર્સ આવશે લાસ્ટ ફિગર. એ જ લાઈનમાં સાહેબ લાસ્ટ કોલમ જોશો તો શેર્સ આવશે 3,40,000. એટલે
ગ્રુપ કંપની ઓફ એન્કર.
હા 3,40,000 શેર્સ for which the agreement has been executed. એટલે સાહેબ કહેવાનો મતલબ now એટલે sum and substance of the agreement. Now let us once again on this background, if we read paragraph page 29 of the agreement, just fine tuning કરી અને then I would read the plaint because case અત્યારે 711 પર તો સાહેબ whatever stated in the plaint has to be believed as correct. That's a settled law. My lords are very much aware. And I would cite number of judgments from 1977 till 2026. There are more than 50 judgments consistently held by Supreme Court that whatever stated in the plaint, pachi then I have to prove in oral evidence. કે ભાઈ આ સાચું કે ખોટું, burden is on me. My lords are very much aware of this. I would cite those judgments at the relevant time. So lordship may kindly see page 29 once again. Just come to the main very now precise submission is page 29 upper 2 places upper vendor has stated that he has signed and on behalf of vendor and others as per annexure A one thing અને થર્ડ પેરેગ્રાફમાં ફર્ધર લખ્યું કે
Vendor
agreed to sell
shares.
shares held by them and others to the purchasers against what કે ભાઈ બધા જ shares મને આપી દેશે 3,40,000 નહીં પણ
So you
total
are the
સાહેબ
purchaser of the shares of Bharat Parental.
Bharat Parental against the discharge of the loan amount and the consideration amount of the sale of shares. And sir, very important thing, bhau interesting one. Sir, I have to purchase not 3,40,000 under this agreement. I have to purchase the shares 29,91,000. સાહેબ એ પેજ 29 ના ટોપ ઉપર લખેલું જ છે સાહેબ આપ જોશો 29 lakhs છે સાહેબ ખરી વસ્તુ કેવું થયું યસ સાહેબ વેરી
That
ઇમ્પોર્ટન્ટ
is
પાર્ટ
about 57.90% of total capital.
યસ સાહેબ હવે સાહેબ ખરી મજા એવી થઈ કે સાહેબ 3,40,000 શેર સિવાય બધા જ પૈસા આપી દીધા સો ધી એગ્રીમેન્ટ હેઝ બીન પરફોર્મ્ડ બાય ઓલ અધર્સ કહેવાનો એટલે મારો આર્ગ્યુમેન્ટ એવું થયું કે defendant number has signed not only on behalf of him but on behalf of others. Others have performed the contract. They have transferred the shares on payment on receipt of this amount. ખાલી 3,40,000 shares જે બાકી રહ્યા જે નથી આપતા
એ કોણ નથી આપતું
એ 2 અને 3 2 અને 3 ડિફેન્ડર નંબર 2 અને 3
એટલે એન્કર ઇલેક્ટ્રિકલ્સ અને એસોટ સોફ્ટવેર
હા અસોજ એ ડિફેન્ડ નંબર 3 છે એન્કર ડિફેન્ડ નંબર 2 છે
બંને they are both same companies.
yes that is my case now એટલે આ લોકો એટલે મેં આ દાવો ફાઇલ કર્યો now kindly see I have therefore સાહેબ અમારે એવું હતું કે અસોજ અને એન્કર we were having very good relations at a relevant time.
બરાબર.
This their original જે આ સિગ્નેટરી જે છે શિખરના જે જાદવજી અને આખું એમનું ફેમિલી જાદવજી શાહ they were on our record which is agreementમાં પણ સાહેબ લખેલું છે they were the directors of our company which lordship would also find that part thing in the agreement itself we see. So we were having very good relations કારણ કે એ લોકોએ મને લોન આપેલી જે તે સમયે because of a relation એ લોન મારે પાછી આપવાની હતી which જે મેં I paid. હવે કેવું થયું કે સાહેબ કે એટલે એ લોકોએ કીધું કે ભાઈ તમે પૈસા એન્કરને આપી દો એટલે અમે એન્કરના નામના ચેકો આપી અને પૈસા આપી દીધા અસોજ એવું કહે છે કે આ પૈસા મને તમે નથી આપ્યા you have given to the different company has no relation with me that is this case.
પણ મિસ્ટર મહેતા તમારો તો એવું હતું કે ડિફેન્ડ નંબર 4 borrowed money from defendant number 2 and 3.
then it's a matter between me and correct you are right but I have એટલે સાહેબ એગ્રીમેન્ટમાં લખેલું છે ને સાહેબ એ પેરેગ્રાફ પેજ 30 ઉપર લખેલું છે આ જ વસ્તુ પેજ 30 એગ્રીમેન્ટનો પેજ 30 the third paragraph that the purchaser shall advance unsecured loans if necessary to Bharat Parentals Limited we shall repay the amount of outs એટલે હું એમને લોન પેટે હું એ પૈસા હું એમના ચૂકવી દઉં છું અને હું આપી દઉં છું એમ that is કઈ એટલે મારે ને ભરત પેરેન્ટલ્સ it's a different agreement there is no the dispute between the two. That is no issue is that 3,40,000 shares I am entitled under the agreement. Therefore, this agreement, as per the agreement, shall be enforced and declared that this agreement valid and subsisting. Away, sir, kindly see, very important is page 46. I have informed time and again, but because of the relations, એ લોકો ડિનાય ના કર્યું કેમ કે રિલેશન્સ બહુ સારા હતા એટલે કે ભાઈ અમે તમને આપીએ છીએ સો ધેર ઇઝ નો ડિનાયલ ધેર કે આપીએ છીએ રિલેશન છે એટલે પછી સાહેબ the thing has gone beyond us so we have called upon them on 2nd 4 2019 plaintiff has addressed a letter to defendant number 1 calling upon કે ભાઈ તમે આ પેમેન્ટ કરો અમારે આ શેર્સ નું. Lordship may kindly read the contents of that letter with reference to our agreement dated 3rd March 2006. My lords are there?
Yes, yes.
3rd March, we hereby write to inform you that it has been substantial time since you assured us transfer of 340 equity shares of Bharat Parental Limited. Here, this is important now. Held by your group company, Asoj Soft Company. So there is a clear case pleading in the documents કે ભાઈ તમારી group company છે.
So it is also Shikhar is also a part of group company 2 and 3.
Yes, that is my case. That is my case.
Okay.
That is my case. Then it's a matter of evidence. कि આ લોકો group company છે કે નહીં, it's a matter of evidence. But in the plaint, I have to only state this. कि આ લોકો group company છે. That's it. That's a settled law.
Okay.
પછી આગળ સાહેબ further આવે. In accordance with the terms and above agreement, we have already made payment of entire consideration amount for 3,40,000 equity shares held by Asoj to your good self and Anchor Limited. બંનેને સાહેબ લખ્યું. પછી further. Whereas
તમારા પ્રમાણે તો નંબર 1 2 3 એક જ થઈ ગયું, એક જ એન્ટિટી છે એ રીતે
yes sir, yes sir, yes sir.
અને તો ભાઈ પુરાવા લઈને એવિડન્સ ને ઇતિહાસ
હા સાહેબ હું એ જ કહેવા એક્ઝેક્ટલી ઇટ્સ અ મેટર ઓફ એવિડન્સ. એ લોકો તો સાહેબ એવું નક્કી કરી દીધું કે અરે કે ભાઈ આ તો શિખરે સહી કરી, અમે સહી નથી કરી. there is no court of action.
ના ચાલે એમાં તો.
અરે ના સાહેબ એ જ સાહેબ આ કઈ
has to be decided after taking evidence.
એવિડન્સ સાહેબ હજી તો આગળ આવશે. અને સાહેબ હું પ્લેન્ટમાં વાંચીશ ને પ્રિન્સિપલ અને એજન્ટનું ક્લિયર કેસ પ્લીડિંગ છે અને એક જગ્યાની સાહેબ 7 places. આગળ સાહેબ હું હજી 8 લેટરમાં સાહેબ આગળ ફર્ધર આવે છે. ઇક્વિટી શેર્સ પ્રાઇવેટ લિમિટેડ બીઇંગ યોર ગ્રુપ કંપનીઝ. ફર્ધર સાહેબ એક જ લેટરમાં ફરી વખત લખ્યું. You had assured us transfer of said shares upon payment of agreed consideration. However, despite numerous reminders and respect, we have not received the said letters till date. We once again request you to kindly look into the matter and go agreed for the earliest. So, on Lordship may kindly see the date that would come for the purpose of limitation. 2/4/2019.
19, yes.
પછી સાહેબ page
Prior to
40.
filing of the suit, you have mentioned this, they are all one entity.
Yes. I have stated that defendant number 1 has signed on behalf of others.
And they have not denied, they have replied of this letter.
ના સાહેબ આ તો 7-11 ને એટલે રિપ્લાય નો પ્રશ્ન ના આવે ને આ સ્ટેજ.
તમે જે લેટર તમે લખેલો એમાં
હાજી
shares and stocks ને
હાજી
2/4/2019 નો જે લેટર લખ્યો તમે
હા.
Shipping and Trading Limited ને.
હા page 42 next sorry page 47 page
Lordship, may I
47.
just intervene for 10 seconds?
No
10
Milord,
seconds of
Milord,
request.
I'm
Please, okay.
I'm sorry
Please,
This
okay,
is-
no problem. I'm asking
Please,
for
no.
permission.
he
Okay,
would be
very
having his turn. This is not a way
Yes.
to argue.
આ page
I'm sorry.
46 માં છે Mr. Mehta.
હાજી.
Page 46.
46 પર હાજી
હા.
હાજી સાહેબ.
એમાં જે લેટર તમે લખ્યો 2/4/2019 નો
હા
શિખર લીઝિંગ ને જે લખ્યો દેસાઈ શેર્સ વાળાએ
હા
Shikhar Leasing and Trading Limited.
હાજી.
Given reply to this letter કે we
યસ પેજ ના એમને રિપ્લાય ના આપ્યો પણ પેજ 47 માં આપ્યો. નેક્સ્ટ પેજ
એમાં લખ્યું છે notice pursuant to-
હા એપ્રિલ 5 2019 શિખર લીઝિંગ એ રિપ્લાય આપ્યો.
and they have not denied that they are not a
Yes,
separate
very much. Can you see the second step?
stated that we are doing the needful and
હા સાહેબ એટલે એડમિશન આવી ગયું we are needful. We are doing the needful and relevant at the earliest.
બરાબર.
એટલે એમાં પછી સાહેબ ફર્ધર મેં લખ્યું પેજ 48 ઉપર 2nd March 2020 એ લખ્યું. એક વર્ષ ફર્ધર ગયું એટલે મેં 2nd માર્ચે પણ લખ્યું 2019 પેજ 48. એમાં ફરી વખત અમે ગ્રુપ કંપનીનો એડ્રેસ કર્યું
બરાબર.
અને વી હેવ કોલ અપોન ધેમ કે ભાઈ કાઇન્ડલી તમે આપો, હવે બહુ સમય થયો. અને પેજ 49 ઉપર નેક્સ્ટ પેજ ઉપર ઈમેલ કર્યો to both of them, to Anchor and defend number 1. Please find attached here with notice. We have also sent hard copy same to your office.
બરાબર.
Page 44. That is the two. This is to
49.
defend number 2. To defend number 2. Now kindly read the plaint. This is very much important now.
Hmm.
I have to state.
Hmm.
Lordship may kindly see now.
Ah.
Page 10. Plaint starts from page 8. But I would request
Hmm.
to go to page 11, paragraph 3.
That on 3/3/2006.
That on 3rd. This is very important. Now I would just emphasize where the plead. I have to plead along with the documents. Because in the 711, my lords are very much aware. The principle is that while deciding the application, 711 filed by the other side, my lords will have to look only plaint and documents, not other things. Their reply cannot be seen. Their contents of the application cannot be seen. My lords will have to see the whether cause of action is arisen against all, first thing, or if anyone is also against that, you cannot reject in toto. That law is settled. And we have to see whether the principles of 711, whether the suit is barred by any law or not, that is to be seen. Now kindly see the plaint in this background. I have to state the pleadings. That's it. Then I would have to prove in the oral evidence. That's it.
Okay.
Now kindly see paragraph 3, sir. That on 3/3/2006, an agreement was executed by plaintiff with defend number 1. પછી સાહેબ next, first મારું emphasis સાહેબ જુઓ, first મારું pleading, who was acting on behalf of 42, including defendant number 2 and 3. પતી સાહેબ, so first pleading I go.
બરાબર.
Now I have to prove it at the evidence stage કે ભાઈ આ એમને સહી નથી કરી એટલે cause of action ના થાય નહીં. I have to prove કે ભાઈ આ 2 and 3 વતી એને કરેલી છે at the stage of evidence. Now it is not at one stage, 5 stages, 5 places. To inter alia purchase of 29,91,000 shares of Department 4 at the rate of 5 rupees થી સાહેબ આ થયા per share, which was cumulatively held by other સાહેબ further બીજું 42 parties. પછી સાહેબ બીજું second representation એટલે pleading, who were being represented by defendant number 1. Second pleading,
બરાબર.
who is being represented by defendant number 1. Pachi further, the said agreement was also signed by defendant number 4 as a conferring party. Individual members, this is important, of shares held respectively of 42 parties is listed at Annexure A of the said agreement. So the agreement ma 42 parties ema defendant number 2 and 3 આવી જાય છે સાહેબ. Copy of the said agreement is annexed. Next, ચાલો બે જગ્યાએ પછી આગળ બીજું આવશે. Paragraph 4, my lords. At the time of execution of a said agreement, defendant number 1 has confirmed and declared that they have 29,91,096 equity shares of defendant number 4 company, and they shall deliver and transfer of all such equity shares in name of plaintiff as per the terms and conditions of the said agreement. Plaintiff inter alia made the payment as mentioned in Annexure B2 of the said agreement. This is very important. Now, step third time.
All the
parties which were being represented by defendant number 1. Tiju pleading type, specific pleading. Pachi further, as per the said agreement, defendant number 3 had authorized defendant number 1 to enter into said agreement with the plaintiff, and defendant number 2, in consonance with the defendant number 1 and 3, has inter alia received a check of so and so. Fourth, now I have specifically pleaded that defendant number 1 has signed on behalf of everybody. They have received the consideration. Now it is the matter of evidence. I have to only plead. Further, સાહેબ હજી તો એટલે 4 વખત આવ્યું, હજી 5મી વખત આવશે. Rupees so and so સાહેબ એ હજી એ સેન્ટેન્સ બહુ અગત્યનું રૂપીસ so and so against the sale of 3,40,000 held by defendant number 3 in defendant number 4 company. My lords, સાહેબ એક પેરેગ્રાફમાં લાસ્ટ લાઇન્સ બહુ સ્પેસિફિક પ્લીડિંગ છે સાહેબ. સાહેબ પેરેગ્રાફ 5,
બરાબર.
despite the plaintiff fulfilling its part of the said agreement, the defendant number 1, 2, 3 failed to transfer the shares of a defendant number 4 company which were in the name of defendant number 3. Specific once again pleading. Cause of action, no specific pleading. Then, Lordship may kindly see next page, page 13. It is humbly submitted that, sir, this is very very important. Kindly see that conduct ne pan sahib consider karo je why 711. Because you are coming to the court, you means the defendant are coming to the court as if they are novice, no relation with anybody, and projecting or portraying before the honorable court that who are you? I do not know, as if I am a foreigner to anything. They are ane awa samaye all have executed the agreement. I have received the amount. Khali આ લોકોએ જ બાકી રાખ્યા. That is the sanctity of the agreement. Kindly see, એટલે બધાએ implement કર્યું, એકે જ ના કર્યું. That means it shows the conduct at whose instance how those persons, they have not showed that bona fide. They are calling upon the court to reject the plaint. That is, this conduct may be considered at the relevant time. Now, in paragraph, the top of page 13, it is humbly submitted that out of agreed 29,91,000 shares, 26,50,866 shares of dependent number 4 have been received by the plaintiff from the other parties on whose behalf said agreement was signed by defendant number 1 company. Sir, further pleading. એટલે સાહેબ કહેવાનો મતલબ બધાએ આપી દીધા. That means
એમણે પોતાના ના આપ્યા એમણે.
હા બધાને આપી દીધા, ખાલી આ એક જ વ્યક્તિ રહી ગયા. Copy of the statement of shares yet to be received from 42 shares the said is prepared by plaintiff is submitted separately. On the extreme right hand side, the said agreement 3,04,000 said held are shown yet to be received from defendant number 3. સાહેબ એ જે મેં પેજ તમને ફરી વખત એની સાથે કમ્પેર કરું જે આપણે વાંચ્યું at page kindly see page 39. સાહેબ જે પેલું એકદમ નાની ફિગર જે હતી ને સાહેબ પેજ 39 આપ જોશો એ આના રેફરન્સમાં આવી સાહેબ.
હા બરાબર છે, રાઈટ.
જે 3,40,000 કે આટલા બાકી રહ્યા એટલે on the extreme right it signed to say 3,40,000 shares are shown as yet to be received from the defendant number 3.
બરાબર.
So defendant number 3 ને એની સામે પણ pleading આવી ગયું. Next, paragraph 7. Plaintiff was instructed by defendant number 1, 2, 3. This is also further pleading. Plaintiff was instructed by defendant number 1, 2, 3 that the payment to defendant number 3 against the number of shares held by it may be named in the name of defendant number 3. એટલે સાહેબ એ લોકો કેસ એવો છે defendant number 3 નો કે સાહેબ પેમેન્ટ તો મને આપ્યું જ નથી, શેર મારા નામે છે, તો તમે defendant number 2 ને કેમ પૈસા આપ્યા છે એટલે મારી સામે cause of action નથી એમ કરીને એમનો કેસ છે. Which then I have to prove at the stage of evidence. I have to say કે ભાઈ તમે મને કીધું એટલે મેં defendant number 2 ને આપ્યું અને 2 અને 3 તો તમે બધા અંદર અંદર મળેલા છો ને ભેગા છો. You have defendant number 1 has agreed on behalf of everybody. Therefore, as per Lordship may kindly see paragraph 7, third line. Therefore, as per the instructions of a defendant, the plaintiff has readily performed its obligation of the said agreement by issuing a check as described in Annexure B2 in consultation with defendant number 1. Then, that over the years, time and again, plaintiff has requested to various different I have called upon them, they have not paid. અને મારા old relation છે, kindly see paragraph 9, which I have averred. That looking to the old relations with the defendants, Lordship may kindly see. I have not stated against defendant number 1. I have said defendants. Especially defendant number 1, the plaintiff continued his exercise to persuade the defendants to perform their part of the agreement, and it later was sent to the plaintiff. J. May Sahib, page 2490. J. May Vancho Sahib, that is at page
46, 47.
46 is start side 24. Yes, sir. Dictated over to the needful. Said letter of plaintiff was replied by defendant number 1 on 55. That is page 47. wherein it acknowledged the letter of plaintiff and assured the some action, but till date no action is initiated by defendant 1 to fulfill his obligation, and said inaction of the defendant has given rise to cause of action. So limitation starts from this date. That is my case. Okay, limitation can be extended by exchange of letters. That's a settled law. I would show the Supreme Court judgments. Copy of the letter dated 2/1 sent to the so-and-so. Then paragraph 10, my lords. Plaintiff on 2/3/2020 sent a notice to defendant number 1.
This application 711 only on the ground of limitation they have thrown out.
ના cause of action એવું કહે છે
Cause
કે
of
ભાઈ
action.
cause of action કારણ કે એવું કહે છે which I would read 711 their application
Hmm.
એ લોકો એવું કહે છે કે તો શિખરે જ સહી કરી છે ને શિખરવતી અમે તો 2 અને 3 ક્યાં પાર્ટી હતા એગ્રીમેન્ટમાં એટલે there is no cause of action therefore the whole should go. Which very and I would show the judgment how each and every sentence is full of errors in principle of law and facts. I would show. Now, then further, my lords may kindly see paragraph 12, page 16. It is a continuing wrong. Continuing a limitation upon principles have it is covered. Of course, limitation shall start from the because of 2/4/2019. જે દિવસે એમને acknowledge કર્યો લેટર ત્યારથી 5/4/2019 5/4/2019 અને paragraph 12 જોશો સાહેબ of the plaint that the bona fide of the plaintiff
Is evident for
is evident for the fact that he has readily issued checks cumulative to a huge amount towards the fulfilling his obligation in terms of said agreement. Despite the receipt of the considered towards the said agreement, defendant are refusing to fulfill their obligation under the terms of said agreement, trying to avoid simply by acknowledging that non-fulfilling of that. Therefore, the cause of action is continuing. So this is a continuing wrong. Then Lordship may cause of action. No paragraph that's not at this stage is not required. I have stated the limitation part in paragraph 17. Limitation shall start from their acknowledgement on 5/4/2019. Suit valuation, we are not concerned. Now, on this count, they have filed an application under Order 711 by both have interesting vastус. Yeah, 711 have they are very kindly see page 66. Page 66. Page 66. This is the application file defendant number 3. Is very much important. Sir, Akka pleadings I would read. There is an acknowledgement on the contrary in their application that yes, it has been signed by defendant number 1 on behalf of everybody. Pleadings are only confined to defendant number 3. Prayer is prayed against all defendants. Prayer shall be read in context of the pleading. That's law is settled. The suit is dismissed against all. Page 66. Now let me read page 66. Paragraph 2. Sir, font, आज application of fonts can be online.
Just a minute, so break 3 minutes.
No, absolutely.
bilang phone ko. Aking phone lagi ya.
હા, કરો ને જેને કરો એને આ લોકોએ રિપ્લાય નહીં આપ્યો તો હું કશું જ નહીં સાંભળું તમારું. હમણાં જે નોટિસ આપેલો રિપ્લાય આપ્યો યુ ડિનાઇડ કે યુ આર નોટ 1 2 3 માં છો તમે કોઈ.
એપ્લિકેશન 3 નંબર
અરે 1 2 3 એક જ તમે એમાં આ લોકોએ લખીને એડમિટ કરીને આપી એમાં તમે કોઈ કર્યું છે તમે? હા, એટલે પણ એનો કોઈ રિપ્લાય છે તમે આપેલો તો હિયરિંગ કરજો, ના આપ્યો તો કોઈ રિપ્લાય હિયરિંગ કરવાની જરૂર નથી. હા, તો ઓપોર્ચ્યુનિટી આપીશ પણ યુ જસ્ટ શો મી ધેટ અધરવાઇઝ નો ખાલી તમે જસ્ટ ખાલી કોઈ હોય જ નહીં તો ખાલી એમને હિયરિંગ કરવાનો કોઈ મતલબ નથી.
Let us argue or let our turn come. Let us.
Yeah, but at that time you show me that.
We will show everything.
બસ.
My learned friend, why in the middle of the hearing show something?
Ask.
બેસો તો. ના ના તમે બેસી જાઓ મિસ્ટર વર્મા, ઊભા ના થાઓ તમે.
This is not a way. This is not a way to argue. In a trial court, I have not come across such type of system where the person who is arguing on his legs and you just interject and say something.
No, Surinder, you continue.
Yes, sir. Sir, I was on page 66.
Yes. Cause of
That's
action.
yes, there's an application filed by the defendant number 3. That's it. Asoj under 711 stating, kindly see paragraph 2. The defendant number 3 served with the summons of the present suit via email because it was filed during COVID, therefore. Defendant number 3 is in process of filing a detailed reply of written statements without prejudice to aforesaid defendant number 3. Lordship, may kindly say I am reading defendant number 3. Defendant number 3 emphasize karu chu ke to show the honorable court that at number of times the application is moved, pleaded only for defendant number 3.
Or particularly defendant number 3 only.
Haji sir is filing the present application seeking rejection of a present suit under the provision of 7 Rule 11 entirely on the grounds, kaya ground, that no cause of action ever arisen against defendant number 3 to file present suit and the suit is barred by provisions of the Limitation Act on 2 counts. Now no cause of action, itle what is their case is no cause of action. Plaintiff is filed by the plaint has been filed by the plaintiff, does not disclose any cause of action against defendant number 3. Kindly see.
Yes,
The defendant number 3 once again is not party to the agreement dated so and so 3rd March 2006, whose specific performance is sought for and therefore defendant number 3 once again is not bound by the terms and conditions of the said agreement. The defendant number 3 was in fact not even aware about the execution and or existence of the agreement dated 3rd 3 until the summons of the present suit was served upon defendant number 3. So this is, I execute nothing karyu, I am not signatory of the agreement, therefore I am not bound by the terms. And further, paragraph 4. It is contended by the plaintiff that on a 3rd 3 an agreement. So kindly see there are 2 admissions. Paragraph M no content, M no admission, acknowledgement. As an agreement was executed by plaintiff with a different number. It is contended. So he himself has said that I have contended. That means I have pleaded.
Yes.
Once he himself is acknowledging that I have pleaded specific case against all, then the question would not be decided at this stage that there is no cause of action against anybody. That's a basic argument of my before the honorable court. Now, they're executed by the plaintiff with the defendant number 1, who was acting on behalf of Lakshmi McKinley. So specific જે મેં વાંચ્યું એ ફરી વખત reiterate કરે છે in the play on 42 other parties, including defendant number 2 and 3, to inter alia so and so so and so. So these are italic words are the part of the pleading. He has acknowledged and pleaded in the 711. Lakshmi McKinley see paragraph 5. The very thing. Now this is my contention. Take it. The other side would say कि साहब आता हमने contention. But paragraph 5 में हमने admission. Defendant number 3 submits that, as per the say of the plaintiff, agreement dated was executed by defendant number 1, acting on behalf of defendant number 3 and others. This is an admission. Age क्या है? Maru's contention, he himself is interpreting. કે 3 અને એના વતી on behalf of defendant. That is my case.
બરાબર.
Defendant number 3 submits. 8 submit કરે. એવું નથી કહેતું. Submits. Allegedly, as per the plaintiff, the defendant number 3 has authorized defendant number 1 to act on the behalf or enter into the said agreement on behalf of defendant number 3, and defendant number 3 has further authorized defendant number 2 to receive consideration for and on behalf of number 3 for the alleged sale of shares. However, plaintiff has not produced any document to substantiate his contention that defendant number 3 has authorized defendant number 1 or defendant number 2 act. But that's a matter of evidence. I have to plead, which I have pleaded, which they have acknowledged. I have pleaded in the documents કે આ બધી group companies છે. So matter shall end from, હું તો paragraph 4 and 5 વાંચ્યું તો matter should end so far as cause of action is concerned in my full submissions. So they themselves have averred. They themselves are saying that the agreement has been executed by defendant on behalf of others. Next page, the next paragraph. Defendant number 3 states and submits that no such authority was given to defendant number 1 or defendant number 2 to act on his behalf. Full stop. સાહેબ આમાં બહુ મજાની વાત આ સેન્ટેન્સ. આમ કહે છે કે અમને કોઈ એગ્રીમેન્ટનું મને ખબર જ નથી. આ તો જ્યારે એગ્રીમેન્ટનો સમન્સ બજ્યો ત્યારે ખબર પડી. તો પછી એને ડિફેન્ડન્ટ નંબર 2 નો ડિફેન્સ કરવાની શી જરૂર છે? આ સેન્ટેન્સ વાંચો. That no such authority was ever given to defendant number 1 or defendant number 2 to act on behalf. સાહેબ 2 ક્યાં આવ્યો? આમ તો કહે છે મારે 2 સાથે કશું નથી. તો him himself is acknowledging. Sir, this is very funny thing. However, the trial court, with highest respect, has now further, I would comment as and when I read the injunction. In behalf number 3 is a private limited company incorporated under the provisions of the Companies Act. Defendant number 3 being a separate legal entity, having a separate identity and common sale, could not have even otherwise authorized the defendant number 1 or defendant number 2, ફરી વખત લખ્યું, which following due process as prescribed under the Companies Act. In absence of such authorization, no cause of action to file the present suit has even arisen to place. Sir, I would take it to the judgments of a Supreme Court non-signatory, though in relation to arbitration, non-signatory is also bound by the conditions of the contract. Current case, I have no main principle. If you are getting the benefit out of the said agreement, means commonality of interest, so then non-signatory is also bound by that. I would show the Constitutional Bench of Supreme Court, 5 judges. The then Honorable Chief Justice Chandrachud, headed by that Constitutional Bench, non-signatory is getting the benefit of the agreement, is bound by the agreement, is bound by the terms and conditions of the agreement. And that even in the arbitration, they bring that non-signatory as a part of the arbitration clause. And arbitration is a contract. They would otherwise argue that sahab arbitration mein to law apply there. Sahab arbitration itself is a contract. So it is applicable to the contract principles. Now I would read further paragraph 7. The plaintiff has filed the present suit in connivance with the co-defendants, not to deprive the defendant number 3 of its legitimate rights. Entire plaint is nothing but a result of clever drafting, whereby an imaginary claim is sought to be created against defendant number 3. Our defendant number 3 badhu આવ્યું. When none lies, no real cause of action has been set. No real cause of action. That means there is some cause of action. This is very important. No real cause of action. That means something is also there. Pleading is how I can substantiate. has been set out in the plaint, but only an illusory cause of action been attempted to be created. A conjoint perusal of the plaint and the list of documents filed along with it clearly does not disclose any cause of action to file present suit against the defendant number 3. On the perusal of the amendments made in the plaint, it is manifestly clear no right to sue as against the defendant number 3 in view of the present plaint as filed deserves to be rejected against the defendant number 3 once again. Now they state the
Defendant number 3 is praying.
but they said, and barred by limitation ni baat kari, there is a contention that this agreement was executed on 3/3/2006. And I have filed suit in the year 2020. And precisely, I may say, because I have to deal with this argument, I have filed, it was affirmed on 9th July 2020, and it is submitted online, 9th July 2020, take it that way. And therefore, it is barred by law of limitation. Sab, apparently, sab, how simple lakshya. कि हो तो 2006 agreement you want to enforce in 2020. Sab, there are two prayers: prayer of declaratory suit first, and the prayer of specific performance. In section 54, I would show those judgments. Just I give you the principle that two things: the denial, the specific performance suit, and the limitation for that, it shall start from the denial of the fact. There are section 54 is in two parts. Section 54 of the Limitation Act provides a limitation that it shall be filed within 3 years. That 3 years shall be mentioned in the agreement. If it is not mentioned in the agreement, you have to take it from the denial of the performance from the other side. Now, my case before the Honorable Court is that a question of law and fact. They have acknowledged in the year 2019. First thing, there is a continuing wrong. Once there is a continuing wrong, because the payment has not been paid till date, so there is a continuing wrong. I show that those judgments as well. And therefore, it is not barred by law of limitations. Now, on this background, I would read paragraph 68. Sorry, page 68, paragraph 8. What is this case?
Barred by limitation.
Barred by law of limitation. Let me read, because I have to read there, of course, while deciding 711 application, the court is not bound to see the contents of 711. The Honorable Court has to see the plaint and the documents itself. Of course, they were right to substantiate his case. But their defense is that pleadings cannot be considered. However, what is their case? Present suit is filed seeking declaration that the agreement dated 3rd March 2000 is valid and subsisting in the further direction, seeking specific performance of the said agreement dated so-and-so against defendant number 3. As in by way of the transfer of 340 shares of defendant number 4 company held by defendant number 3, along with a permanent injunction in respect to further transfer of said shares. No explanation has been provided by the plaintiff as to how the suit is filed within the prescribed period as provided in the Limitation Act against the defendant number 3. Admittedly, the reminders have been issued by the plaintiff to defendant number 1 about alone. Admittedly, it is in the defendant number 1 who is in connivance with the plaintiff has acknowledged the alleged non-performance of 5/4/2009. No such reminders have been issued to defendant number 3. Consequently, defendant number 3 has never acknowledged any liability under the agreement. That is his case. Now, kindly see paragraph 10. The agreement whose specific performance is sought by the plaintiff is of the year 2006. Therefore, the plaintiff was required to file the present suit within 3 years of the alleged execution of agreement that is on or before 3rd March 2009. The present suit is actually filed in and around 9/7/2020 and is therefore clearly barred by the provision of the Limitation Act 1963. Now, I have to show from the agreement the date is not mentioned. Once date is not mentioned, then I would show the provisions of law, not at this stage. So this is a thing. Then Lordship may kindly see paragraph 11, 12 is not required. Same thing, narration of the same thing. And suppression ની પણ એક એમને there is a mention. However, the trial court has not believed this suppression.
આખા O711 ના બધા defendant number 3 is specifically it is filed only on for behalf of defendant number
Defendant number 3. Now kindly see the prayer,
3.
page 72. The Honorable Court be pleased to reject the plaint of plaintiff for non-disclosure of the cause of action, and be further pleased to reject the plaint for being barred by provisions of Limitation Act under the provision of 711 Court Procedure. That's it. So defendant number 3 prays. So it is not mentioned anything. If we read the prayer along with the pleadings, it is confined to number 3 only. હવે
ઓર્ડર કયા પેજમાં છે સોરીનભાઈ આનો?
હા, હવે હું ઇમ્પ્યુન ઓર્ડર સાહેબ વાંચું.
711 નો ઓર્ડર કયા પેજ?
Yes. એ જ વાંચું છું. Kindly see page. એક જ સેકન્ડ સાહેબ, immediately after my appeal memo, page સાહેબ સેપરેટ હશે કેમ કે એનું પેજિનેશન નહીં હોય સાહેબ. Immediately page 15 પછી એનેક્સ કરેલું છે સાહેબ.
છે રાઈટ.
Yes. Sir, I would read. It's a very longish judgment. Now, analysis page 19 થી થશે સાહેબ, right and top ઉપર page 19 થી start થાય છે. Page 19. Analysis. સાહેબ બધા જજમેન્ટ્સ ને બધું સાહેબ હું અત્યારે it's not at this stage. જરૂર પડશે તો હું રિજન્ડરમાં કવર કરીશ.
બરાબર.
પણ પેજ 19 થી એની એનાલિસિસ છે. We have to read this. I have given my thoughtful consideration to the submissions made by the learned advocate for both the parties. સાહેબ હવે બહુ I would read the judgment very carefully, and each and every sentence in my response submissions full of errors of principle of law and fact both. Now the Honorable Court understands that while deciding 711, what you have to see, that principle has been mentioned. However, he has not followed, which I would take it. It is a settled proposition of law that a court at the time of considering the application under Order 711 shall confine itself to the averments made in the plaint and the documents annexed thereto. It shall not look into defense of the defendant. Sab, this best correct principle of law is mentioned. However, he has gone beyond this. Now, kindly see, it is also settled proposition of law that a trial court can exercise the power under Order 711 at any stage of the suit before the registering plate or after issuing summons to the event. That's fair enough. I read over the averments made in the plaint and also documents. Now, kindly see, he has considered the averments. જે મેં સાહેબ આપને બતાયા 5 જગ્યાએ એ બધા જ averments એને પ્લેન્ટના લખ્યા.
બરાબર.
So he has followed this. He has taken out અને સાહેબ list of documents પણ એને મૂક્યા. Fair enough. અને સાહેબ 4.2 at page 24 ટોપ ઉપર સાહેબ છે ને રાઈટ હેન્ડ સાઈડ ટોપ ઉપર પેજિનેશન લખેલું છે.
24 છે બરાબર.
હા અને પેરેગ્રાફ 4.2.
The defendant number 3
has submitted this application on the ground that no cause of action has ever arisen in favor of the plaintiff to file a present suit barred by law of limitation, insufficient court fees stamp, suppression, and no cause of action. That's now on first ground of cause of action is concerned. Now let us see now what is cause of action, how he interprets perusal of the plaint in the present case and the agreement filed along with the plaint at Mark 4.2. It clearly shows that even as per the pleadings in the plaint and causes of action and the clauses of the agreement in question, the parties to the agreement were only to the plaintiff and defendant number 1, other than defendant number 3, who has filed application for rejection of plaint. There is no dispute about the fact that the plaintiff entered into the said agreement only with the defendant number 1 and confirming party, the defendant number 4. It is an admitted position that other than aforesaid defendant number 1, none of the defendants were party to the said agreement dated 3/3. The agreement could therefore be specifically enforceable only against those defendants who was party to the said agreement. This is error. First error, which I would show straightway, should I show that judgment of
The agreement could therefore be specifically enforceable only against those defendant who was party to the said agreement.
हाँ, એટલે સાહેબ, this is wrong.
You have argued earlier before, sir.
સાહેબ, 3 કોર્ટો સાહેબ,
એટલે
with highest respect.
erroneous findings એવું લખેલું છે આમાં.
હા સાહેબ, એટલે એવું થયું, સૌથી પહેલા I started before Honorable Justice Mangre સાહેબ. Mangre સાહેબ, during this COVID and other, then thereafter, it was argued at length. Then after the Honorable Justice Mangre was elevated now to the Honorable High Court. Now he is sitting judge of the Honorable High Court. Then after Justice Desai, Utkarsh Bhai Desai, he is also elevated as a High Court judge. The third one, the Honorable Justice Vadodara, he is also elevated. Now with a lighter moment. Now it is a turn of my lords. In a lighter way. Absolutely, because this is a serious matter. So we should also keep the atmosphere lively. Therefore, I am in a absolutely lighter. I have taken little liberty.
4.3 માં page 24 માં છે બધું.
હા સાહેબ, એટલે સાહેબ આનું જજમેન્ટ હું તમને સાહેબ સાઇટેશન આપી દઉં. That settle law કે ભાઈ ગ્રુપ ઓફ કંપનીઝ નો કેસ, એક જ સેકન્ડમાં સાહેબ, એ સાઇટેશન આપી દઉં, પછી હું સાહેબ હું વાંચીશ. એકચ્યુઅલી એમાં છે આપણે સાહેબ એક આખું બંડલ આપેલું છે. એમાં કંઈક there are some 21 judgments. Unfortunately, sir,
તમે સબમિટ કર્યું છે હશે મારી પાસે.
હા સાહેબ, આખો બંચ જ છે સાહેબ, આખો બંચ છે સાહેબ,
જોઈ લેજો ને માથે હશે.
આખો બંચ છે સાહેબ.
કેલા છે બધા.
અને હું તમને સાહેબ એક જ સેકન્ડમાં કહી દઉં એ જજમેન્ટ. સાહેબ, this is very important issue. Has been time and again this non-signatory of contract ની વાત કરું છું સાહેબ, કે even non-signatory is also bound by the contract. Unfortunately my colleague, sir, 2022, there is item number 21 sir of the bunch.
હા તમારે છે અહીંયા મહેતા, અહીંયા બધું
છે સર. ના એટલે આઈટમ નંબર મેં છે ને સાહેબ નંબર આપેલા છે, એમાં આઈટમ નંબર 21 છે.
ઓએનજીસી વાળું છે, ઓએનજીસી.
હાજી બસ, હાજી સાહેબ, હાજી સાહેબ. This judgment delivered by this પછી further considered confirming. પણ હું સાહેબ એ નોન સિગ્નેટરી નો પ્રિન્સિપલ આમાંથી વાંચી લઉં છું. જે લેટેસ્ટ જજમેન્ટ મેં નથી મૂક્યું, પણ આનું આ જજમેન્ટ હેઝ બીન કન્સિડર્ડ by the consider. આ 3 બેન્ચનું છે, 5 જજીસના બેન્ચે ફરી કન્સિડર કર્યું. પણ કોક્સ એન્ડ કિંગમાં પણ લોર્ડશિપ મે કાઇન્ડલી સી paragraph 26 of this judgment. My lords would able to find that item number 21 ONGC.
હા છે.
હાજી સર.
Yes, I got it.
હાજી સર.
Arbitration and Conciliation Act.
Yes. Now paragraph 21. The principle at સાહેબ હું કહું છું, the group of companies was subsequently applied by 2 judge bench in so and so for determining if a non-signatory foreign company within the same group of companies could be included in the domestic arbitration. This court noted the principle formulated by this court and noted the applicability after assessing. Sir, this is most important. Assessing the alleged common employee between the 2 companies in the same group was factually established and having no connection with the foreign company. Mere existence of the indemnity by the foreign company in the absence of any other factors would not signify his intention to be bound by the arbitration agreement and or deriving benefits from the performance of the underlying contract. On a side, they have considered in paragraph 25, sir, they have considered the other judgments which I may not read, પણ પેરેગ્રાફ 25 થી સ્ટાર્ટ થાય અને એનો પ્રિન્સિપલ 26 નો છે, પણ આઈ વુડ રીડ ફ્રોમ 25. સાહેબ ધીસ ઇઝ વેરી મચ ઇમ્પોર્ટન્ટ. આ ઇસ્યુ એટલો બધો સાહેબ ડિબેટેડ થયેલો ઇન ધી ઓનરેબલ સુપ્રીમ કોર્ટ એન્ડ અધર હાઈકોર્ટ્સ કે નોન સિગ્નેટરી જ્યારે કોન્ટ્રાક્ટ થયો હોય તો બાઇન્ડિંગ કેવી રીતે ગણાય નોન સિગ્નેટરીને? આર્બિટ્રેશનમાં મેને થર્ડ વ્યક્તિએ સાઇન કર્યું તો હાઉ ધીસ કેન બી થર્ડ પર્સન ઇઝ બાઉન્ડ બાય? તો કોર્ટે એવું કીધું કે ભાઈ કેમ બાઉન્ડ થાય? પ્રિન્સિપલ એવું કે સપોઝ કોમોડિટી ઓફ કોમન ઇન્ટરેસ્ટ હોય અને યુ આર ડિરાઇવિંગ ધ બેનિફિટ, then it is bound. Now paragraph 25. Recently, John Fellas elaborated on the principle of binding a non-signatory to an arbitration agreement from the lens of a doctrine of estoppel. He situated a rationale behind an application of a principle of a direct estoppel against competing consideration of party autonomy and consent in interpreting the arbitration agreements. Fellas observed that non-signatory parties can be bound by the principle of direct estoppel to prohibit such a party from deriving the benefits of a contract while disowning the obligation to arbitrate under the same. એટલે સાહેબ તમે બેનિફિટ એક બાજુ એગ્રીમેન્ટમાં પૈસા લઈ લીધા, હવે કે સાહેબ મેં સહી નથી કરી એટલે મને બાઇન્ડ નથી, એટલે તમે ધીસ ઇઝ એસ્ટોપલનો પ્રિન્સિપલ લાગ્યો અને કોર્ટે કીધું પછી સાહેબ ધીસ વેરી બહુ ઇમ્પોર્ટન્ટ, બહુ સરસ લખ્યું છે. There are at least two distinct types of estoppel doctrine that apply in the non-signatory context: direct benefits estoppel theory and the intervened estoppel theory. The direct benefits theory bears the hallmark of estoppel doctrine, prohibiting a party from taking inconsistent positions or seeking to have it both ways by relying on the contract when it works to his advantage and ignoring it when it works to disadvantage. Sir, પૈસા લઈ લીધા અને પછી ના લીધા પછી કહે કે ના હવે હું I am not bound. Sir, very thing it has happened in our case. Further, sir, the direct benefits of doctrine reflects that core principle by preventing a party from claiming rights under the contract, but at the same time disowning the obligation to arbitrate in the same contract. Then I would not read the next paragraph. At the paragraph 26 માં એમને રેશિયો નક્કી કર્યો કે કયા સંજોગોમાં they are bound. The deciding whether a company within the group of companies which is not a signatory to arbitration agreement would nonetheless be bound by it, the law considers following factors. 2. Mutual intent of the parties. Sahib, our agreement no. Now I would request if we see the agreement once again, અને એક point ને સાહેબ સીધું directly આપણે apply થાય. Kindly see the agreement once again. સાથે સાહેબ
If you go to judgment, whether signing of the agreement by defendant number 3 does not make any difference. Once
કારણ કે સાહેબ kindly see benefit લીધા page 29 સાહેબ, page 29 of the commonality of interest had a benefit, તો એગ્રીમેન્ટ ને નોન સિગ્નેટરી ને પણ બાઉન્ડ થાય. સાહેબ હવે પેજ 29 પર ટોપ ઉપર સાઇન બાય અધર્સ, પછી સાહેબ સેકન્ડ પેરેગ્રાફમાં 2 અને 3 ના પેજ 29 નો એડ whereas the Bharat Parentals has also borrowed from the his outstanding loans 53 લાખ 64 લાખ to anchor and associate એટલે ડિફેન્ડ નંબર 3 એટલે 2 અને 3 આ લોનની એમાઉન્ટ મળી ગઈ,
બરાબર,
એટલે એ લોકોને બેનિફિટ મળ્યો. સાહેબ પછી નેક્સ્ટ પેરેગ્રાફમાં ફરી વખત has agreed to sell aforesaid shares held by them and others to purchasers agreed to buy the said shares and also arrange to the payment. I would request thereafter કે આટલા પૈસા મારે એમને આપવાના. એ સાહેબ પેજ 25 ઉપર લખ્યા. શેર્સની વેલ્યુની પેરેગ્રાફ 25 ના થર્ડ પેરેગ્રાફમાં લખ્યા. આ જ એગ્રીમેન્ટમાં પેજ 33 ઉપર જે એનેક્સર એ છે એમાં એ શેર્સ કેટલા છે, કોને સાહેબ આ જે પેજ 33 ઉપર લેટ મી સોરી મારે એક વખત એક્સપ્લેન કરવાનું હતું સાહેબ. આ 42% છે, આ બધાએ આટલા શેરોને આટલા પૈસા લીધા જુદા જુદા, બધાએ સાહેબ એન્ફોર્સ એટલે પરફોર્મ કર્યો કોન્ટ્રાક્ટ. ખાલી પેજ 34 ઉપર એમાં સાહેબ જો સાહેબ સપોઝિંગ બહુ લોજિકલ છે સાહેબ તું કે સાહેબ બધા જ કરે અને એક જ વ્યક્તિ ના કરે, ધેટ મીન્સ વોટ?
એટલા 3,40,130 નું છે.
યસ, એટલા સાહેબ એક જ વ્યક્તિએ નથી કરતું, ધેટ મીન્સ ઓલ હેવ અગ્રીડ. કારણ કે એટલે શિખર હેઝ સાઇન ઓન બિહાફ ઓફ એવરીબડી હેઝ પરફોર્મ. So how the third person can say, અને કે અને સાહેબ એ લોકો એવું કહે છે, સાહેબ બહુ 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 ઇલોજિકલ ઇરેશનલ આર્ગ્યુમેન્ટ કેમ કે સાહેબ એવું કહે છે કે સાહેબ મને કઈ મન થાય છે એમનું આ અસોજના શેર્સમાં લખવાનું નામ. Why should I mention? મારું નામ જ લખી નાખ્યું હોત ને મારે જો શેર લેવાના હોત. Why Asot name is mentioned? Because I have to recover. સાહેબ મારું નામે લખ્યું, કોઈ ત્રીજાનું મેં કોઈ બીજી કંપનીનું નામ કે બીજા ઇન્ડિવિડ્યુઅલ એન્ટિટીનું નામ લખ્યું, અનુજ નામ લખ્યું, કારણ કે they have agreed, they are all in close group company નો પ્રિન્સિપલ એપ્લાય કર્યો, they have અને એવું નથી સાહેબ, they have received the consideration. That's the best part. My best argument, once they have received the consideration, that means they have received the benefit under the agreement. Now they cannot say, no, I am not the signatory, therefore I am not bound. This is the conduct. This is the conduct. This is dishonest conduct. Now kindly see page 26, paragraph 26. Mutual intent of the parties. એટલે mutual intent માં બધે આવી ગયા, for and others માં શબ્દ આવી ગયો agreement માં. Second now, sir, page 20, paragraph 26 of the judgment I was reading. Paragraph 26. Mutual intent of the parties. 2. Relationship of a non-signatory to a party which is a signatory to the agreement. Which may I have said that the all and enavati ene karelo che, that I have to plead. Then I have to prove the relation at the time of trial. Third, commonality of the subject matter. Yes, commonality shares of ekna nahi 42 na shares અને discharge of the loan amount. 3. Next, the composite nature of the transaction. બધું ભેગું સાહેબ, composite nature of transaction. Performance of the contract. So મારું તો performance સાહેબ 5 are falling under the agreement. And they are bound by the agreement. Therefore, though he is a non-signatory, he is bound by the agreement. Therefore, the cause of action is arisen against all. Now, in the below, say paragraph વાંચવા જેવો છે. Consent and the party autonomy are different question. Unregarded in section 7 of the Act of 1907 of the Act of the Arbitration. Okay, section 7 માં આ consent and party autonomy mention નથી કર્યું. However, this is important. A non-signatory may be held to be bound on a consensual theory founded on agency and assignment or a non-consensual basis such as estoppel or alter ego. Now જે એનો ડિફેન્સ જે કહે છે કે મને તો ખબર જ નથી, મને તો કન્સેન્ટ જ નથી, અમે તો કંઈ આપ્યું જ નથી, અમને તો જ્યારે સમન્સ આવ્યો ત્યારે જ મને ખબર પડી. This is the thing, એનો જવાબ. Founding on agency and assignment or on a non-consensual basis such as estoppel or alter ego. Sir, Gary Bond, which is one of the best author and the jurist in world of in the subject of arbitration in the world, Gary Bond. These principles would have to be understood in the context of the present case, where ONGC's attempt at the joinder of JDL to the proceeding was rejected without adjudication, application for discovery and inspection of document. We are not concerned of fact. So this is the principle. હું આ સાહેબ આપને બીજું સાઇટેશન હું જે કોન્સ્ટિટ્યુશનલ બેન્ચનું હું તમને આપું છું સાહેબ, પણ આ this is the principle કે non signatory is also bound by the agreement. Now let us go to once again the impugned judgment. Okay, how he has, and this is a point of law. Lordship may kindly see, other side might argue કે ભાઈ સાહેબ આ પોઈન્ટ તો તમે આર્ગ્યુ કર્યો જ નથી. How this is at appellate stage? That is a point of law. Because this is which I would show the judgment, 711 should not be considered and appreciated in a most casual manner. Because you are while considering 711 and the suit is rejected, then you are denying the right of a person. It is a very risky affair. Court should be very careful and circumspection while dealing 711. Now, Lordship may kindly see, I was reading paragraph 24 in the middle. There's a wrong finding. It is admitted position that other than, I was reading કે આ finding અહીંયા ખોટું થયું in the middle pen in paragraph 4.3, if my lords is with me. It is an admitted position that other than aforesaid defendant number 1, none of the defendants were party to the said agreement dated so and so. Agreement could therefore be specifically and only against those defendants who was party to said agreement. There can be no doubt about the same. The rule of pleadings incorporated in 47 and 48, Forms 47, in Appendix A to the Code of Civil Procedure, specifies the pleading necessary in a suit seeking specific performance of the agreement. This rule requires specific pleadings with regard to the date on which the plaintiff and defendant entered into agreement in question, with document being annexed to the plaint and the description of movable property. This is very important. If we read the Form 47 and 48 of a CPC, Seb, it is related to movable property. He himself has said, immovable and plaint and with movable. This shares in question. It is 47 and 48A for immovable property. I would read for immovable property. Immovable. How is deriving the principle of immovable property, which is against law. Once again, and I would read the judgment on the outset. The plaintiff in the present case, the law is it is not a function of a court to guide me or to advise me. Sir, how money advice court? Then I would certainly show a direct judgment of a Supreme Court. It is not a function and the court to advise me in the judgment. The plaintiff in the present case needed to specify in the pleadings in the plaint as regards the details when he entered into agreement for purchase of a movable property of so-and-so shares with the defendant number 3, here and how he was seeking a decree for specific performance against the defendant number 3. Sir, it's a matter of trial. This is a matter of trial. In the present case, plaintiff has obviously not made any such statement in the respect of defendant number 3, because even as per the agreement on which he relies, it is evident that the said agreement was executed between him and defendant number 1. Thus, a finding, there is absolute lack of pleadings and in fact no material to show that any agreement in the present case could be specifically enforced as against the defendant number 3, and it has found that defendant number 3 was not a signatory to the agreement, and therefore agreement could not be enforced against them. Sir, to them. Sir, can you just second error? Defendant number 3, sir, paragraph, let us read once again. Baddu against defendant number 3. Prayer is against defendant number 3. Pleadings in the 7 illa defendant number 3. Now in one sentence he has brushed and he has painted everybody and brought everybody, all defendants in one. Once them.
The defendant number 3 was not signatory and therefore the agreement could not be enforced
against them.
That
one to paper, one to signatory sir. Sir, how the error, how ex specie erroneous, with highest respect to the trial court. Ex specie, sir, with highest respect to this judgment shall be brushed aside in this one sentence. There is no application of mind or principle of law. And it would be, sir, further, it would be inequitable to enforce. Sir, equitable principle kya hai 711 ma? How is bringing equitable principles? Law no principles. I am enforcing my right under the Act, under the Specific Relief Act, under the Contract Act. How equity kya diya hai? It would be inequitable to enforce specific performance of the such contract. It was also observed that it could be safely held that there was no cause of action against the defendants. Sub-dependent, but common aayegi. This was found on the basis, on the aforesaid agreement, that defendant number 3 became the sole and exclusive owner of the 340,000 shares of defendant number 4 company as a legal position which is not even controverted and denied by the plaintiff in the plaint. And also defendant number 3 was not party to the agreement in question. There was prima facie evident that in none of any documents to support plaintiff's contention that defendant number 1 was acting in consensus of defendant number 3. There was no question of granting a decree of specific performance as against the defendant. Seba, clear. Seb, once again, if may go to the pleading, 5 places I have stated, I have to only narrate facts. Okay, he has signed on behalf of everybody. And I have specifically averred that he has signed on behalf of 1, 2, 3. Seb, documents nahi. Seb, I have annexed those documents. Group company no principle lakhelo છે. અંદર એનો everment પણ છે. અને સાહેબ આમાં principal and agency no principle લાગે. One speak on behalf of others. આ તો it's a matter of trial. સાહેબ એટલે I am having those judgments. Now kindly see. એટલે paragraph
તમે છે ને સોરીનભાઈ
હમ.
you just give a brief થોડું તમારું લિખિત દલીલો આપી દેજો રિટર્ન આર્ગ્યુમેન્ટ્સ
ના હજી સાહેબ હજી આગળ કઈ નહીં સાહેબ મારે હજી જજમેન્ટ્સ બતાવવાના છે પણ આઈ એમ ગોઈંગ ફર્ધર સાહેબ આ ઇટ વુડ નોટ બી લોંગિશ મેટર છે મિસ્ટર યાજ્ઞિક વુડ ઓલ્સો એન્ડોર્સ ટુ ઇટ કેમ કે સાહેબ અમે 3 જજીસ સાહેબ બબ્બે 3 સિટિંગ થયેલા
ના પણ પછી હું સાંભળ્યા કરીશું તો ઇટ ઇઝ નેવર એન્ડિંગ એ તમારે આટલું
ના
બધું
એ તો મારે રિટર્ન સબમિશન્સ આપવા જ પડશે
જ્યારે ખ્યાલ આવી ગયો કે ભાઈ ડિસ્પ્યુટ કયો છે ને આમાં ક્યાં છે તો પછી અનનેસેસરી
સાહેબ હજી સાહેબ એટલે મારે જજમેન્ટ્સ તો મારે વાંચવા જ પડશે કારણ કે
વાંચો તમે પણ થોડું અત્યારે તમે
હા
કન્ટિન્યુ
હું બ્રીફ કરું સાહેબ હવે ફર્ધર ખાલી હું વાંચી જાઉં છું એ જ પેરેગ્રાફમાં નીચે ઇટ ઇઝ સિગ્નિફિકન્ટ ધેટ એ કોઝ ઓફ એક્શન નું ફર્ધર ડિસ્કશન કરે છે ઇટ ઇઝ સિગ્નિફિકન્ટ ડિફેન્ડ નંબર 3 ઇઝ નોટ સિકિંગ રિજેક્શન ઓફ પ્લેન સાહેબ he is admitting qua the particular portion of a plane or qua any relief sought in a plane but he is seeking rejection of plane as a whole સાહેબ એવું ક્યાં છે સાહેબ રોંગ ફાઇન્ડિંગ સાહેબ ફેક્ચ્યુઅલી રોંગ ફાઇન્ડિંગ એમનું તો ડિફેન્ડ નંબર 3 પૂરતું જ છે તો પણ એને he is saying કે એઝ એ હોલ એ રિજેક્ટ કરવા માંગે છે સાહેબ ફર્ધર ફાઇન્ડિંગ ખોટું
એમને હોલ રિજેક્ટ કર્યું એટલે પછી એ રીતે ફાઇન્ડિંગ્સ આપશે ને એમણે જે રીતે કરવું એ રીતે આપે ને ફાઇન્ડિંગ્સ
but Sam, it is not permissible. I would show the judgment stage. Sam, that's I may not say anything further.
ના બરાબર એમાં નહીં આ તો
Next paragraph. It is significant that in the plane the plaintiff has sought relief of direction to defend of 1, 2, 3 transfer of outstanding shares of the Refuting company in the name of memory further seeking direction. This to affect transfer of shares company in the name of the in the records, etc. Such reliefs can be granted even if the entire case of the plaintiff is to be accepted only against the signatories to agreement, defendant number 1, while such reliefs can certainly not be granted against other defendants at all. સાહેબ આ ભૂલ સાહેબ એડમિટેડલી ડિફેન્ડન્ટ નંબર 1 ને તો સહી કરેલી છે એની સામે તો કોઝ ઓફ એક્શન થઈ કે નહીં ટેક ઇટ ધેટ વેર હિઝ કેસ ઇઝ હાઈએસ્ટ તો હાઉ કેન યુ ડુ ધીસ સાહેબ ડાયરેક્ટ જજમેન્ટ 2018-11 SCC પેજ 780 અને પછી લેટેસ્ટ અમને છેલ્લે ઓનરેબલ જસ્ટિસ there is item number 6 of the list. Item number 6 in the list. 2018-11 STC page 780. Lord, this is a Sejal. This judgment was cited, huh? Sir. Of course, it has been discussed here. But I'm looking for my copy. Sir, unfortunately, I am having another matter with a different court. My colleague has gone there and he has taken the copies of all judgments. ખાલી મારી ભૂલથી ચાલુ કોમન પેલો એ બન્યો છે
ના વાંધો નહીં તમે સાઇટેશન્સ માટે રાખજો આપણે વી વિલ
હા એ તો I would show પણ સાહેબ મને મારી કોપી મળી જશે કેમ કે આખું હતું બંચ જ હતું પણ મને મળી જાય તો સાહેબ હા સાહેબ મારી એક બીજી કોપી મળી યસ સર સેજલ નો
અહીંયા તો છે મારી પાસે તો છે જ બધું આખું
હા સાહેબ આઇટમ નંબર 2 એટલે સોરી આઇટમ નંબર 6 આપ જોયો સાહેબ સેજલ ગ્લાસ 2018-11 SCC હું વાંચ્યું સાહેબ પેરેગ્રાફ 3 directly on the point. Sejal Glass Limited. મેં એક પેલું ઇન્ડેક્સ પણ આપ્યું છે 2018-11 SCC 780 આઇટમ નંબર 6 છે સાહેબ જે બંચ આપ્યું છે ને સાહેબ મેં જજમેન્ટનું આઇટમ નંબર 6 સાહેબ there are two bunches એટલે આ 12 સ્ટાર ભલું જો તો કેમ કે સામાવાળાએ પણ આપ્યા છે એવું બને એ બંચ ના આવે
બીજું એક બંચ છે
A which is a very bulky bunch where item number 6 is marked. हाँ बस ये 6 number નું અને આ જજમેન્ટ આ પ્રિન્સિપલ ઇઝ રીઇટરેટેડ ઇન 2025 and 2026 ફરી વખત પણ હું એ જજમેન્ટ હું પાછળથી બતાવીશ બેસિક પ્રિન્સિપલ સાહેબ આમાં બતાવી
अच्छा, सेजल ग्लास versus
Sejal Glass.
Spirit Merchant Private Limited.
Yes, yes, sir. Kindly see paragraph 2. Facts and Cottage 2 lucky. Paragraph 2. An application dated 8/7. My lords have got it? My Lord Justice, yes.
8/7 was filed by the defendant.
Filed by the defendants under Order 711, stating that the plaintiff disclosed no cause of action. By the impugned judgment dated 7/9/2016, it has been held that a plaintiff is to be bifurcated. It discloses no cause of action against the directors, the defendant number 2 to 4, but the suit is to continue against defendant number 1 company. It is further been held that the defendant number in any case is barred from filing a written statement in the suit as is taken to inordinate time. We are not concerned. So same principle के 2 to 4 માં થાય અને now the provisions of rejection plaint has been mentioned. After that, what is important? સાહેબ એ જે કોડ પૂરો થાય provisions of 711. What is important will above paragraph 4. What is important to remember is that a provision refers to the plaint, which necessarily means a plaint as a whole. It only where the plaint as a whole does not disclose whole as a cause of action that 711 springs into being and interdicts a suit for proceeding. Now, certain judgments are being followed. 4, 5, 6 and 7. Kindly go to paragraph 8. A ratio છે sir. એટલે હું paragraph the earlier judgments have been considered and the Honorable Supreme Court said, we are afraid that this is a misreading of the Madras High Court judgment. It was only on the peculiar facts of that case. One top section is only one defendant led to the rejection of a plaint as a whole, as no cause of action would remain against the other defendants. This cannot elevate itself into a rule of law that once a part of a plaint cannot proceed, the other part also cannot proceed, and the plaint as a whole must be rejected under Order 7, Rule 11. Step finding. In all such cases, if the plaint survives against certain defendants and or the properties, Order 7 will have no application at all, and the suit as a whole must then proceed to trial. He is now, kindly see page 26. Page 26. Top step wrong, second erroneous finding.
Such reliefs can be granted even if the entire case.
Such relief can be granted even if entire claim is to be rejected only against signatories. એટલે સાહેબ એને એડમિટ કર્યું કે ડિફેન્ડ નંબર 1 વતી તો કોઝ ઓફ એક્શન છે, પણ જેને એગ્રીમેન્ટ નથી કર્યો, સાઇન નથી કર્યું, એટલે બધી જતી રહે, which is against standing in the eyes of law. આ જજમેન્ટ એક વતી જો થાય તો બધા વતી રિજેક્ટ ના થાય સર. It is enough. એક વતી જાય the suit is maintainable against all. સાહેબ ફર્ધર સાહેબ હજી આની આ જ વસ્તુ લખેલી છે. If suit is maintainable against one, it must go for trial against all. And this is also reiterated by the Supreme Court in 2025. I would cite that citation and a judgment at the relevant. But our basic principle, this judgment was cited, huh, સાહેબ આગળ આવશે.
તમે ત્યાં બતાવેલું આવું 711 વખતે ત્યાં બતાવેલું હતું?
હા સાહેબ આવશે આગળ સાહેબ, આગળ એનું ડિસ્કશન આવે છે સાહેબ. I would take it that portion. Then this is the finding which I cannot go further. બીજું striking out pleadings we are not concerned. Like this is the direct judgment that it cannot be rejected. Now next paragraph, aforesaid factual and legal position being admitted. સાહેબ એટલે બધું જ આખું નિકળી જાય છે. Aforesaid factual legal position being admitted and accepted in the plaint, I fail to understand how and what basis plaintiff claims right of transfer of outstanding 340 shares of different 4 company in the name of plaintiff that was held in the name of different number 3 in terms of actual holding as evidenced by agreement. In the aforesaid background, it is to be held that the plaintiff does not disclose any cause of action for relief paid. There is direction to the defendant number 3 to execute a transfer of 347 shares of the defendant in the plaintiff. There does not exist any legal right which plaintiff is entitled to invoke and enforce. Further wrong find. Ena basis for a right to exist, there must be correlative duty which can be enforced in a law suit. Sab enforced करेली duty under the agreement. A right cannot exist without enforceable duty. Ownership means a bundle of rights which would normally include the right to execute and the transfer of property in a manner one wants, subject to contractual obligations. A himself is subject to contractual obligation. There is a contractual obligation. As agreed or a statutory prescription. In the present case, pleading failed to establish violation of a statutory right or a breach of a contractual obligation and creates enforceable right in the court of law in absence of any such right or even the claim could not move. સાહેબ હવે જો plaintiff જે હું સેજલ ક્લાસની વાત કરું છું અહીંયા એનું મેન્શન છે. Plaintiff advocate relied in the case of Madhav Prasad, bench of co-equal stand, affords a judgment in the case of Sejal Glass, which I have read, was directly on the point. By following the state judgment, it was held that the plaintiff, he wants to, with highest respect, learned judge wants to distinguish. Well, it cannot be distinguished. On the contrary, it is his right to distinguish. If the plaintiff survives against certain defendants, Order 7 will have no application and the suit as a whole must proceed. Sir, finding Lakhu, which I read, finding Lakhu, however, he mentions some different thing of earlier judgment. In the state case, defendant bank had claimed that the suit was barred in the 34 of the Act. It was also claimed that amendments in the plaintiff did not spell out the case of the fraud against the bank. In such circumstances, it was held by the Honorable Supreme Court that the plaintiff could not have been rejected only against the defendant bank. Additionally, other hand, defendant number 3 is relied on the judgment of the Honorable Supreme Court in the case of a church of so-and-so. Ane Sab has relied upon this judgment of church no case, which in fact, it supports me. I would show church case, that is, my lord would find paragraph 8. Sorry, item 8 of my judgment. Sab, judgment, it's good, judgment supports me. સાહેબ આ જજમેન્ટ સાહેબ થોડું લાંબુ બધી ફેક્ટ્સ વાંચવી પડશે. સોરી હો સાહેબ, થોડું કેમ કે આ સપોર્ટ કરે. અમાર સાહેબ ઓન ધ કોન્ટ્રી એવું કરેલું કે suit continue against the defendants. એવું આવે છે finding. અને I wrongly relied upon paragraph 29. If we now said આમાં બહુ જ carefully
2012 નું છે ને
2012 8 STC which is prior to this. એવું એ કહે છે કે કઈ નહીં, let me read that judgment and elaborate. સાહેબ આમાં ફેક્ટ્સ થોડી ક્લમ્ઝી છે.
સોરેનભાઈ આપણે આ જજમેન્ટનું સાઇટેશન્સ માટે ક્લેરિફિકેશન પછી રાખીશું.
હા એવું રાખી સાહેબ. હા
સાઇટેશન્સ.
હા ઓકે. yes my lord.
facts it stands on its own leg.
હા એ હા બરાબર છે. એટલે ના પણ ઇવન સાહેબ આ જજમેન્ટ મને સપોર્ટ કરે છે. નેક્સ્ટ પેરેગ્રાફ સર, નેક્સ્ટ પેરેગ્રાફ પેજ 28 ઉપર. In the facts of the present case, judgment of the Honorable Supreme Court in a case of a church is directly applicable. Our later judgment, Sejal Glassnu, shall be considered, not the earlier one. In charge of the executive society represented by chairman so-and-so explained that the and ABC, Leminat and other 3 judgments here, my lord, that learned trial court mentioned. Cause of action means every fact which, if traversed, would be necessary for the plaintiff to prove in order to seek a decree and relief against a defendant. Cause of action requires infringement of a right or a breach of an obligation and comprises of all material facts on which right and claim for breach is founded. There is once act done by the defendant to infringe and violate right of breach. That is a principle of law. We do not deny. That's okay. And also in T. Trevendaram, Satyapal and another 3 held that if the plaintiff is manifestly vexatious, now how
again the article section 54 by limitation.
હા પણ સાહેબ એ તો આ કેસ 77 નો સાહેબ that has been considered by Supreme Court and distinguished. સાહેબ એ આખો સૂટ જુદા ગ્રાઉન્ડ ઉપર તો એને ડિક્રી થયેલી, સૂટ ફાઇલ કરેલો, ડિસમિસ થયો અને for a longer period he is set for a idle, and I would show that and I can distinguish. It is not applicable. And held that if plaintiff is manifestly vexatious, meritless and groundless, in saying it does not disclose clear right to sue, it would be right and proper exercise power under 711. Mere contemplation or possibility that a right may be infringed without any legitimate basis for that right would not be sufficient to hold that a plaintiff discloses cause of. So the cause of action on this count has been rejected. The aforesaid position laid down by Honorable Supreme Court applies. Well, there are series of judgments of what is cause of action. Lordship may kindly see. Should I only give citation? Evidence type હું રાખું ને અત્યારે.
સાઇટેશન્સ તમે છે ને સોરીનભાઈ એક સાથે આપજો બધા મને થોડી બ્રીફ નોટ સાથે આપજો તમે.
હા અને સાહેબ પણ મારે I have to read those thing because to appreciate the ratio of the judgment. I'm sorry, but I would crave leave of this honorable court to re-argue only question of law purtu or only judgments purtu, not further.
ના ના આપણે we are not closing your arguments, we are keeping it open. તમે એક બ્રીફ નોટ સાથે મને પણ આપી
હા
દેજો.
હા ના એટલે
Then you argue તો આપણે we can
fair enough.
simultaneously.
હવે second issue આવે છે limitation.
બરાબર.
આ પોઈન્ટ સાહેબ કોઈ દિવસ આર્ગ્યુ થયો જ નહીં અહીં સુધી જ, કેમ કે મેં અત્યાર સુધી સાહેબ જજમેન્ટ્સ બધા જુદી જુદી કોર્ટો પાસે જુદા જુદા સમય બતાવ્યા અને ટાઈમ પૂરો થઈ ગયો, કેમ કે these are very lengthy matter. એટલે હવે આપે કીધું એટલે જજમેન્ટ્સ અત્યારે બતાવતો નથી, એટલે we are saving the time now. So limitation point has never been argued before earlier honorable court. Now I read the limitation points. So far as 4.4 page 29. So far as the issue of limitation is concerned, it is true that a limitation can be ground for rejection of plaint in exercise of power under order 7.11d.
લિમિટેશન તો I am satisfied કે એમાં કઈ તમારું 2019 ના કરસ્પોન્ડન્સ વિશે unless contrary એ લોકો કઈ આર્ગ્યુ કરે તો પછી if I need clarification.
હા એટલે એ લોકો they would argue on this point. એટલે સાહેબ મારે ખાલી એટલું જ બતાવવું છે જે છે ને limitation act is that section 54 is incorporated. એ જજમેન્ટમાં હા એમાં ચોખ્ખું લખ્યું છે ડેટ ફિક્સ ફોર પરફોર્મન્સ. હવે એગ્રીમેન્ટમાં ડેટ ઇઝ નોટ ફિક્સ or if no such date is fixed, plaintiff has noticed that performance is refused. Now performance, my case is performance is refused કે what કે અમે કરીશું એવું સાહેબે કીધું. page 46 47 of the plaint. The defendant number 1 has executed agreement on behalf of everybody and 42 others has agreed that we do the needful. Sir, if we do the needful.
તમે નોટિસ આપે એમાં બી they have not mentioned anything about limitations કે you are not
ના કશી નહીં. on the contrary એ જ વખતે એમને કહી દેવું
they will look into the matter and they will revert you.
it's a matter of evidence. It's a matter of evidence.
Positive reply કે ભાઈ and
yes.
In fact they have admitted that it is outstanding.
yes અને એટલે અને બીજું શેરોનું પરફોર્મન્સ નથી થયું એટલે કન્ટિન્યુઇંગ રોંગના પ્રિન્સિપલ્સ પણ આમાં લાગે. સર આઈ હેવ ગિવન ધ લિમિટેશનના જજમેન્ટ્સ પણ આપે મને કીધું એટલે એ જ વખતે હું ફર્ધર હું કહીશ.
હા એટલે એમાં કેવું છે લિમિટેશન્સ આ લોકોના ડિફેન્ડન્ટ્સને શું કેવું છે આર્ગ્યુ કરી.
હા એ પછી જ હું આપીશ.
કરી હોય તો આઈ વિલ રિવર્ટ.
શ્યોર પણ સાહેબ એક જજમેન્ટ છે જસ્ટ કન્ટિન્યુઇંગ રોંગ માટેનું અને limitation shall extend from the date of can be extended because of the exchange of letters. That is page that is item number 13 of the list 2020 17 SCC page 260 which I have which is part of the list item number 13 13
એક મિનિટ. અચ્છા શક્તિ ભોગ ફૂડ ઇન્ડસ્ટ્રીઝ
હા શક્તિ ભોગમાં સાહેબ એમાં એવું જ હતું કે લેટરથી એક્સટેન્ડ કર્યું. જસ્ટ લેટ મી રીડ ઓનલી ટુ પેરેગ્રાફ્સ એટલે એમને પણ ડીલ કરતા ફાવે. પેરેગ્રાફ 17 ફર્સ્ટ. પેરેગ્રાફ 17 ઓફ ધીસ જજમેન્ટ.
Limitation Act.
Thus the expression used in Article 113 with the right to sue accrues, which is markedly distinct from the expression used in other articles in the first division of the schedule dealing with suits, which unambiguously refer to the happening of a specified event, whereas Article 113 being a residuary clause and which has been invoked by all three courts in this case does not specify happening of a particular event as such, but merely refers to the accrual of cause of action on the basis of which the right to sue would accrue. Now, this is a principle. Now, kindly go to paragraph 22. Okay, event three cause of action can be a reason. Now, paragraph 22.
It is well established.
It is well established position. The cause of action for filing a suit would consist of bundle of facts. Further, the factum of a suit being barred by limitation ordinarily would be mixed question of fact and law. Even for that reason, invoking 711 is ruled out. In the present case, the assertion in the plaint is that appellant verily believed that its claim was being processed by the regional office, and regional office would be taking appropriate decision at the earliest. એટલે સાહેબ મેં લેટર લખ્યું એમને કીધું કે we do the needful. The belief was shaken after receipt of a letter from the senior manager of the bank dated 8/5/2002, followed by another letter dated 19/9/2002 effect that the action taken by bank was in accordance with the rules and the appellant did not correspond with the bank in that regard any further. એટલે સાહેબ કર્યું તો પણ કોઈ એક્શન ના લીધી. This firm response from the respondent bank could trigger the right of the appellant to sue the respondent bank. Moreover, the fact that appellant has eventually sent a legal notice on 28/11, again on 7/1, then file a suit on 23/2/2000 is also invoked as giving rise to cause of action. Whether this plea is taken by appellant is genuine and legitimate would be a mixed question of fact and law depending on the response of the respondent. Sahib, pati gayi sahib aayi hai baat. Even further, I also explained in 23 on a paragraph. It is also explained in paragraph 23 further. Reverting to argument, take that exchange of letters or the correspondence between the parties cannot be basis to extend the period of limitation. In our opinion, for the view taken by us hitherto, same need not be dilated further, inasmuch as having notice from the governments in the plain that a right to sue accrued to the appellant on receiving letter from senior manager dated and the particular letter so and so, again from refusal by the respondents by the advocate dated in response to the legal notice, once again on the follow-up legal notice, plain filed in February would be well within the limitation, considering the formal events of firm response by the respondents on 8/5, particular 19/9, correspondent and suit thereafter, including two legal notices sent by the even if it disregarded, the suit file is would be within the terms of section 113. So exchange of letters and paragraph 30 taking over review of the matter, therefore we are considered opinion that the decision of trial court, the first appellate court and the high court in fact situation rejecting the plain question of orders cannot be. D is barred by law of limitation. As a result, same are quash and set aside. So exchange of letters, limitation is extended. This judgment has been again considered. I would show those principles have आपने समझाया. This is 2020-17 SCC. Then it is have limitation. I may not go further. In view of this, the order at this stage, limitation and cause of action, 3 point आया cause of action, limitation, and a non-signatories no principle. Now, sir, it's very important what has happened. Under 4127, I have filed an application at the appellate stage that certain documents may be taken on record. Sir, a separate application file करेली है. That my lords would find exhibit 16 houses, 15 or 16. અને સાહેબ આમાં આ જ્યારે મેટર મુકાઈ ત્યારે એટલે ક્વેશ્ચન એટલું પહેલા આગલા ઓનરેબલ કોર્ટ સાથે સાહેબ આ ઇશ્યુ થયેલો. Of course, I must be candid and fair to the honorable court. The issue was, it was before Honorable Justice Mengre and then Honorable Justice Vadodara. K 4127 shall be heard along with the main matter or separately. Exhibit 16 के 15 से है. हमारा पर 15 के 16 हो गई.
16 છે.
हाँ जी, 16. એ સાહેબ આ એપ્લિકેશનમાં I have mainly મારો કેસ એવો થયો ખાલી to show to justify કે these are part of the group companies અને એ લોકોનું internal 1, 2, 3 નું cross investment છે એકબીજાની કંપનીઓમાં. They are having the direct directorships અને મેં બધા documents મૂક્યા આની સાથે, which are those documents of the government record, ROC ના record છે. જે એમને જ સાહેબે દરેક પબ્લિક કંપની ને પ્રાઇવેટ કંપનીએ માય લોર્ડ આર વેરી મચ દે હેવ ટુ ફાઇલ એન્યુઅલ રિટર્ન્સ showing the investment, showing the directorship નું બધી details, annual returns under section 189 of the 1956 act જે તે વખતે અને એ વખતે એમને ફિઝિકલ ફોર્મમાં ફાઇલ કરવાના હતા જે તે વખતે પછી આ એમેન્ડમેન્ટ થી 2006 થી બદલાઈ ગયું ને ઓનલાઈન કરી શકે ઓનલાઈન ધીસ ઇઝ ધ આ ફેક્ટ્સ હવે સાહેબ મેં પેરેગ્રાફ એટલે I have to justify for filing this 4127.
તો 58 મિનિટ આજે એક્ઝિબિટ 15 છે તો રિપ્લાય છે એ લોકોનો
ના એટલે એક્ઝિબિટ 16 હશે એટલે સાહેબ એક્ઝિબિટ 16 હશે
ના 15 ની 14 હશે એમની આ તો 15 તો એમનો રિપ્લાય છે એમાં છે ને એમાં એ લોકો એવું રિપ્લાયમાં આ રીતે છેલ્લો પેજ છે એમાં રિપ્લાયમાં
ના સાહેબ એટલે એમનો રિપ્લાય એટલે એમનો
રેસ્પોન્ડ નંબર 2 નો રિપ્લાય છે એમાં
હા એટલે સાહેબ એ જે રિપ્લાય કર્યો ને
એપ્લિકેશન ધ ડિઝર્વ્સ ટુ ડિસમિસ વિથ કોસ્ટ એટલે તમારી જે એક્ઝિબિટ અને પહેલાની હશે ને આગળની હશે જુઓ એક્ઝિબિટ 14 જુઓ તો
સાહેબ મારી સ્ટે એપ્લિકેશન હશે આઈ થિંક મારી એપ્લિકેશનમાં બહુ ચોખ્ખું છે એપ્લિકેશન ફોર પ્રોડક્શન ઓફ એડિશનલ એવિડન્સ અંડર સેક્શન પેજ 2 પર કેમ કે એટલા બધા એટલે મને એવું લાગે સાહેબ મને ફિઝિકલ ફોર્મમાં આવવું પડશે એવું કેમ કે એટલા બધા ડોક્યુમેન્ટ છે એટલે આ વગર ઓલવેઝ મેટર આ
તમારે છે ને એમના 14 15 તો રિપ્લાય છે તમારા જે એડિશનલ ડોક્યુમેન્ટ્સ
એ પછી સાહેબ એક્ઝિબિટ
તમારો એક્ઝિબિટ 6 છે
હા એક્ઝિબિટ 6 છે 15 નથી યુ આર રાઈટ સર આઈ માઇટ ફોર માય એક્ઝિબિટ 6 છે સાહેબ સ્ટે એપ્લિકેશન પછી તરત યસ
તમારા ડોક્યુમેન્ટ્સમાં તો શું વાંધો છે યાર તમારા તે વાંધો છે તમારા બધું
હા એમને એ લોકોએ
કેવું છે એમાં ઓર્ડર કરી દઉં છું આજે હું તમે યુ હેવ ફાઇલ્ડ યુ ઓલરેડી યુ ફાઇલ્ડ ધ રિપ્લાય that is because that is તો 0711 માટે આર્ગ્યુ છે પણ આપણે just this is not we have not argued on the point of this exhibiting of documents we have not argued on the point of exhibiting documents now we are only arguing just you was briefing about this 0711 નું જે ઓર્ડર છે એના માટે આ તો interim applications છે એમાં I'm saying interim I have to argue this is not a part of a record તો આપણે ભાઈ મિસ્ટર મહેતા
હાજી સાહેબ
તો તમારે એક્ઝિબિટ 6 નું પણ આર્ગ્યુમેન્ટ્સ બાકી છે
હા બરાબર છે તો સાહેબ હું એટલે કરું ને સાહેબ એટલે પછી સાહેબ આપની જે અનુકૂળ તારીખે કેમ કે આ
છે ને એક સાથે આર્ગ્યુમેન્ટ્સ કર્યો બધા એક એક એપ્લિકેશન્સમાં
Lordship, may I be permitted to speak for 10 seconds? In fact, I'm concurring on what Mr. Mehta says. कि आपनी convenience से physically एक दिवस राखी लीजिए. We will come down.
Come down and you prepared you come with the written arguments. I will not.
We will submit a return. My lord wants written submissions from both sides.
Production of documents. I will pass the necessary orders immediately. I don't want to hear anybody. Even Mr. Mehta ne પણ નથી સાંભળવા માંગતો આમાં તમારે એમાં what objection you are having?
Both parties have objection.
You have already filed the reply. You have mentioned everything in your reply.
This is not a part of a record before a trial court. There is a decree that has been passed on the basis of a record that was before a trial court.
This is a production of documents. As far as Exhibit 6 is concerned.
New documents that are being placed on record. I will show the judgment. I will show the law on that.
Robin, we would want to.
Reply, no, you file your reply, no. Then what else you want to show?
That is what I am saying.
You give me in writing whatever you want to show. You just give in writing and I will give you half an hour for that.
But like them.
For everyone, Mr. Mehta, તમે પણ you just prepared with your brief.
હા અનુ સાહેબ હું
everybody.
Yes. 4127 સાહેબ 20 મિનિટમાં હું બતાવી દઈશ 20 minutes.
Manoj, may I submit? We have some objections. We will conclude in 20 minutes whenever your lordship permits. On that day, I am undertaking that we will come. We will not stretch it.
So after 4 o'clock, I will આજે exhibit 6 નું સાંભળી લઈએ બધાનું 20 minutes everyone.
Your lordship may keep a day. They may be heard. Appellant might.
So you just go and come and we'll keep it on Monday or Tuesday.
Yes.
Only on હવે છે ને we'll go by one application.
Yeah.
Mr. Mehta,
My lords.
આપણે exhibit 6 નું જે exhibiting documents છે બરાબર છે
હાજી સાહેબ
જે તમે આપેલી છે ઓર્ડર
હાજી હા 4127
That
4127
41 Rule 27 under section 1071D.
D બરાબર છે સાહેબ ઓપ્સીપીસી
Running away from arguing. On the very date we said we will argue every.
સાહેબ એટલે મને લાગે છે સાહેબ બધું જ ભેગું કરવું છે જે આપની અનુકૂળતા છે
આપણે જો 1 by 1 લઈએ બરાબર છે
હા
હું તો કહું છું તો અમે ઓર્ડર જ કહ્યું બી હર્ડ along with exhibit 1 એટલે
હા બરાબર છે સાહેબ કરી શકો છો સાહેબ
ચલો હું
Yes.
am passing it
હા
over.
સાહેબ it can be heard along with that fair enough
બધું, ચલો.
fair enough fair
હવે
enough
now I am hearing you તમારે exhibit 1 ના આર્ગ્યુમેન્ટ જ સાંભળ્યા આપણે બરાબર
Yes.
હાજી સાહેબ
Now,
આ બધું
41,
exhibit.
27
એ
and
બધું
judgment,
exhibit.
they will argue. Then it will our turn to argue on both the issues.
to be heard along with exhibit 1 જ કરી દઉં છું
Yes.
હાજી હાજી બરાબર છે સાહેબ બરાબર છે
અને તમારા જે ડોક્યુમેન્ટ્સ પ્રોડ્યુસ કર્યા છે એ પણ I will consider at the time of passing orders.
Yes. Yes.
હાજી હાજી સાહેબ બરાબર છે સાહેબ
Hearing our argument, your lordship will consider.
બરાબર છે ડન સર
Tuesday, your lordship, Tuesday.
ના સાહેબ હવે સાહેબ એવું થશે મારી રિક્વેસ્ટ છે સબ્જેક્ટ ટુ માય લોર્ડ્સ કન્વીનિયન્સ
હા.
સાહેબ વેકેશન ઇઝ નજીક ટ્રાયલ કોર્ટમાં વેકેશન હાઈકોર્ટ થી એક વીક મોડું આવે છે તો એ વીકમાં જ સાહેબ અમે આવી જઈએ એટલે અમારે હાઈકોર્ટનું કોઈ કામ ન નડે સામાવાળા પણ સાહેબ આવે છે હાઈકોર્ટ થી જ આવે છે મિસ્ટર યાજ્ઞિક તો જો સાહેબ આપણે
I have one submission. I would want a separate opportunity for my exhibit 6 hearing.
હા હા ચોક્કસ
Please.
પ્લીઝ
Order to be
એ તો
heard
બધાને
exhibit 1.
Fair enough.
6 નું જે છે production of documents it will be also considered at the time of hearing of exhibit 1.
બરાબર છે
Separate નહીં it will take long time 2021 થી pending છે this matter is pending since 2021.
સાહેબ એટલે 11 જો તમને ફાવતી હોય તો 11 મેં બધી જ એક જ દિવસમાં આપણે સવારના 11:30 આપણે સ્ટાર્ટ કરીને મેટર બધા તરફથી પૂરી થઈ જશે એક જ દિવસમાં
Mr.
ઓર સબ્જેક્ટ ટુ માય લોર્ડ્સ કન્વીનિયન્સ સબ્જેક્ટ ટુ માય કોઈ પણ તારીખ પણ સાહેબ મારી રિક્વેસ્ટ એવી છે કેમ કે વેકેશન ઇઝ કમિંગ આફ્ટર 2 વીક્સ
તો
request- એટલે સાહેબ મેમાં સાહેબ આપણે કોઈ પણ તારીખ રાખો આપના વેકેશન પડતાના આગલું વીક એટલે સાહેબ તમારે પણ રસ ના હોય
Mr. Yagnik,
Yes,
Right.
your lordship.
6 decided
6575.
6 decided now. I have ordered passed to be heard along with exhibit 1. એટલે તમારું exhibit 1 ના argument સાથે જ એ થશે એમાં.
હા બરાબર છે તો
એટલે
એ
exhibit છે.
હા બરાબર છે સાહેબ પરફેક્ટ
તમારે પણ ભાઈ મિસ્ટર તમારે ફાઇનલ આર્ગ્યુમેન્ટ સાથે જ આવવું પડશે exhibit 1 ના.
હા
Exhibit is already
I
decided
am
now.
not running away. I am not saying no.
What
to
I
your
am
lordship.
saying is
Yes,
now
I
you
am
come
ready.
prepared.
Lordship, if I may.
Not exhibit 6. Whatever you citations you want to show, you
Yes.
show at the time
Your
of
lordship
hearing
will
the final
hear me on
argument.
exhibit 1.
Ah, yes.
Your Honor, if I may just interrupt once.
Ah,
Your Honor, the law, as we had also argued before, is that Exhibit 6, which is Order 4127, has to be heard first to decide if in Exhibit 1 these documents can be heard or not. That strategy and that format was already agreed upon before. That is why earlier also, if Your Honor would see the Rojkam, Exhibit 6 was heard and it was on order of Exhibit 6. Unless Exhibit 6 is adjudicated Exhibit 1, how will it be possible? That is my submission.
અરે પણ if I make out a case on exhibit 1 only 4127 in support of 1 it is the card should come
Your Honor,
the horse should come
my
first and
right
before
to
that
add,
the card
my
should
right
come.
to argue.
you have already filed a written statement.
Yes.
You both have filed a
Yes.
written statement. Now,
Yes.
whatever you want to argue, you come on Monday. I will give you 20 minutes. There
Yes,
is no
on exhibit 6. On
exhibit 6 if you want to argue.
Yes, want to argue, we are opposing it.
We are opposing,
It
yes.
was taken for the order before your lord. Because that is not a part of the original record. How can it be considered in a, that is, we have to make a.
સાહેબ એવું નથી સાહેબ રોજકામ એવું નથી સંભળાયેલી ખરી પણ એ લોકો
On this without listening to us. It can't be, your lordship may keep it on Monday for the hearing of exhibit 3. We will argue it.
સાહેબ એવું નથી my learned friend is not sure I will also everybody should confirm સાહેબ એવું થયું on the contrary other side argument was that it should be heard along with on the contrary
No, your lordship.
however because they have shown the judgment 2012 of a Supreme Court that is Hakim Chand case Iqbal Hakim Chand case which is also on record Iqbal Chand said that it shall be heard along with the main. Therefore, however, Honorable Justice Vadodara said, okay, we can first of all decide section 4127. However, there was no order. Matter continued. No order was passed, though it was heard in part. It was no order was passed. It was
It
there
was
are
not final, it was not finally argued.
no. It remained pending. It remained pending.
Finally, it was taken for order of exhibit. It was taken for the order of exhibit.
Order of exhibit, yes, your lordship.
હવે રોજકામાં શું બોલે છે?
Exhibit 6, it is written.
It is written in the notes coming.
Let us see. I do not know. Learned court master can confirm this.
Exhibit, what is exhibit 35? પણ જો તો exhibit 35 શું છે?
Record यहाँ पे नहीं पड़ा, hence it is-
સાહેબ એ 35 નો મારું ઓબ્જેક્શન છે એટલે ઓર્ડર ઉપર આ નથી સાહેબ 4127 નથી સાહેબ એવું થયું સાહેબ 4127 ની વોઝ આર્ગ્યુડ સાહેબ એવું થયું બહુ ઇટ્સ અ વેરી ટિકલિશ ઇશ્યુ સાહેબ વોટ હેઝ હેપન કે 4127 માં આર્ગ્યુમેન્ટ મારા થયા ડિફેન્ડ નંબર 3 એ 4127 નો રિપ્લાય આપ્યો નથી સાહેબ એ લોકોએ પ્લેન્ટનો રિપ્લાય આપ્યો છે 4127 નો રિપ્લાય નથી આપ્યો અને રિપ્લાય આપ્યો નથી અને એમને મારા આર્ગ્યુમેન્ટ્સ પૂરા થઈ ગયા 4127 ના at the stage of their reply produce certain documents at the stage of reply which he has not filed any reply to the 4127 therefore I objected ke bhai and I have shown the principle of order 6 rule 2 3 and 4 of CPC ke if you do not file a reply to the application, it is deemed to be believed that you have admitted. On this count, that Exhibit 35 જે છે એમના documents. I have objected, I have produced Supreme Court judgments that this is not permissible. It is deemed to have been admitted. A Exhibit 35 નું મેં objection લીધું written. જે Exhibit 35, 34, 35 આવશે મારું written objection છે. એ objection નું hearing થયું. 4127 નું hearing જે કહે છે my learned friend is not correct. My learned friend shall also confirm his own record and also record and kindly see the yes and kindly reconfirm the hearing taken place. It has also been recorded. It has been recorded in the records of the court. So my learned friend may not misguide and mislead honorable court which has been done.
Exhibit 6 exhibit 6 ની application છે તમારી છે બરાબર?
હાજી સાહેબ.
So you are ready to be heard along with exhibit 1 આમાં?
હા મને કોઈ વાંધો નથી કરો ને.
Yes, so I am already passing the necessary.
હા એ તો on the other side
wherever you want to go. No, it is his application. When he says, when applicant himself says that he want to hear this application at the time of exhibit 1.
I consider it. I am not saying it is not an exhibit by the Mara injunction no order nothing to it final injunction આપજો. There is a decree that has suit that has been filed before the learned trial court with the document.
Mr. Mehta, તમારો કોઈ objection છે exhibit 1 ના આમાં?
Your lordship, sir.
Or exhibit 6 to be order to be heard along with exhibit 1.
ના મને કોઈ વાંધો નથી સાહેબ actually
Because it is your application.
yes
Your lordship, we agree.
yes
to
yes
the-
So
એમ
let
જ
them
હોય
take
સાહેબ
it up.
Mind hearing.
સાહેબ law એવો જ છે સાહેબ you are right
બસ તો હું exhibit 1 નો order કરું છું to be heard along with exhibit 1. બરાબર?
yes
હા બસ હવે.
અને law that's a correct law but however the earlier court said can I want to hear from
જૈનિશ શાહ ક્યાં છે બોલો શું કેવું છે એમને?
Your lordship, I am Aditya Yagnik here. It may be heard together. Yes, your lordship.
Appellant advocate request to hear this application along with exhibit 1. Hence
Yes,
it is heard along with exhibit 1. બરાબર?
yes એમ જ હોય actually
Maybe fix on the date now.
તમે arguments કરો છો આમ delay tactics કરો છો?
Sir, see the Rojka, I never taken a date in 5 years.
અરે હોય અરે come on અરે આવું નહીં આવું please do not make wrong statement
No, lordship, they were not.
આવું ના બોલાય
Your lordship, just we have objected. Your lordship, here as well exhibit 1.
Apparent advocate request to hear the present application along with exhibit 1. Hence.
મારી રિક્વેસ્ટ એવી છે કેમ કે અમારે પેલા જ્યારે નેક્સ્ટ ટાઈમ આર્ગ્યુમેન્ટ થશે તો રિટર્ન આર્ગ્યુમેન્ટ્સ લઈને જ આવીશું વિથ જજમેન્ટ્સની તો મારી રિક્વેસ્ટ એવી છે કે આપને અનુકૂળતા અને સબ્જેક્ટ ટુ અધર સાઇડ્સ કન્વીનિયન્સ ઓફકોર્સ 11 ને જો
11, your lordship, there is some difference. Please, Sovereign bhai, please. પહેલેથી જ મેં કીધું.
તમારે જો I don't have any objection in accommodating you. તમે બંને લોકો બધા decide કરી દો કે which date you want.
May I give options? 28/4/15/65/75. 15/65/75.
તો 7 એ રાખો.
7 perfect. 7 perfect.
7 sir. 7th May.
હા.
સાહેબની પછી જે અનુકૂળતા સાહેબ. નતર 11 નું આખું વીક સાહેબ છે 11 થી 15.
11 થી 15 નહીં. I have a partner in Delhi એ વખતે.
તો
હા,
7th
તો 11 થી 16 કોઈ દિલ્હીમાં સાહેબ દિલ્હી તો is so fast in deciding the matter સાહેબ.
એવું છે.
11 થી
આવી
16 5 દિવસ
7/5 please. 7/5 11 some commitment 7/5 કરો ને please.
તરુણભાઈ કઈ રાખ્યું છે બોલો તમારે convenient
મારી રિક્વેસ્ટ સાહેબ એની પાર્ટનર મેટર છે એટલે એની તારી પેટર્ન 11મી તારીખે છે ને?
11th માં તો I am in an arbitration. મારે 12 કે 13 માં એ વીકમાં જવાનું છે 2 દિવસ. So that is my
તો
so I'm
14-15 રાખો.
requesting
14-15 રાખો.
14 નથી પ્લીઝ સૌરીનભાઈ એ વખતે નથી ટ્રાવેલિંગ આઈ એમ ટ્રાવેલિંગ પ્લીઝ
તો
7/5 પ્લીઝ
એના આર્ગ્યુમેન્ટ પછી રાખજો સાહેબ. લેટ મી માય
નહીં 7/5 પ્લીઝ
પણ તમે છો જૈનીબેન તો છે જ ને. શી ઇઝ આર્ગ્યુઇંગ ધ મેટર. યુ આર
I'm not
ટ્રાવેલિંગ.
doing-
જૈનીબેન ઇઝ નોટ ટ્રાવેલિંગ.
No, she is traveling in this. અરે પણ સૌરીનભાઈ we have always been communicative of dates.
હા તો ભાઈ આઈ એમ યુ આર ઓલસો નોટ
13/5
અરે મારી
13/5
સિકનેસ સાહેબ
30 પણ I'm answering પણ તમે બોલવા તો દો મને પણ 13/5 એમ કહી રહ્યો છું 13/5
હા 13 બરાબર.
ઓકે 13/5
13
13
સાહેબ મારી સિકનેસ મારે ઓપરેશન કરાયેલું ને સાહેબ ઇટ હેઝ બીન પોઇન્ટેડ આઉટ કે કોઈ ઓલ્ટરનેટિવ એકોમોડેશન કરો એવા સાહેબ ઓબ્જેક્શન.
એવું કશું નથી this is
આટલું બધું પર્સનલ સાહેબ થયેલા છે.
nobody has got a personal સૌરીનભાઈ it doesn't
ના પણ you are
Please.
seeking your only day.
No, but no. That is a wrong statement to make. We can check Rojka. We have tried to we are
No, 13/5
please.
fair enough.
Fair enough.
જો તો exhibit 6 કરો લાવો 13/5 રાખીએ સૌરીનભાઈ બરાબર
હાજી સાહેબ I am grateful to my lord. I am grateful to my lord.
હા, અને exhibit 1 નું hearing
હા exhibit what?
કોઈ પણ pending applications હશે it will be decided along with the exhibit 1.
yes એટલે 41/27 નું પણ થઈ જશે એનું hearing.
હા એ પણ નહીં જોવાનું એ પણ નહીં. એમાં પણ exhibit 35 છે સૌરીનભાઈ તમારી એ પણ exhibit along with exhibit 1 કરી દઈએ.
હા એ પણ સાહેબ કરી લઈશું.
Yes, we agree to that. We agree to that.
કારણ કે મારો ક્વેશ્ચન એવો હતો એમાં કે મારા આર્ગ્યુમેન્ટ પતી ગયા પછી they cannot bring documents. That's a settled law. કેમ કે હું આર્ગ્યુ આઈ એમ એ પ્લેન્ટિફ મારી પાસે શું પ્રેઝન્ટ છે પછી જ હું આર્ગ્યુ કર્યું. એ લોકો જવાબમાં કોઈ નવા ડોક્યુમેન્ટ મૂકે હાઉ ઇટ ઇઝ પોસિબલ. That is settled law.
Arguing for matter ચાલે ડિગ્રી ક્વેશ્ચન આપે.
સારું આપણે 13/5 આમાં બરાબર
8/5 with a subject to my lord's convenience may I leave?
હા ઓકે
Please. હા.
Yes.
આજે બપોરે નાખ્યું છે પણ હવે એવું હતું અમારે અર્જન્ટ તાત્કાલિક પેલા પીઆઈ બહુ વખતથી બીમાર હતા એટલે મહિનાથી આજે જ ઉભા થયા છે અને આયા છે આજે જ ઉભા
બરાબર તો
તો
જેવો
મેં ગરિયાભાઈને કીધું છે કે આજે ચીફ લઈ લેવામાં આવે કોઈ જુનિયર બેઠા હશે ક્રોસ માટે સાહેબ મંડે ટ્યુઝડે જ્યારે આપને અનુકૂળ હોય તો બપોરે પછી રાખી દેજો તો અમે ક્રોસ કરીએ. મેં ગરિયાભાઈ સવાર આવવાનું કીધું મેં કીધું આપ સવાર આવી જાવ તો લઈ લઈએ પણ એ કે ના મને સવાર નહીં ભાવ.
મેટરમાં કઈ છે નહીં લાંબુ
હા એવું
આ મેટરમાં
ના એવું સમજી ગયો. પેલો
તમારે જે તારીખ જોઈએ આપી દેશે તમે લઈ લો.
મારે રિટર્ન આર્ગ્યુમેન્ટ મેં આપી દીધા કે મારો ઓરલ ગણી લેવા મેં કોશિશ બી આપી દીધી કે સાહેબ
સારું
જજમેન્ટ પણ લઈ લો એમ.
હા તો લઈ લઈશ કયો નંબર છે
સીરિયલ નંબર 17 થાય
જોઈ લે
એ જ પાર્ટી
આ છે ને એની અંદર મૂકી રાખવાનું. હવે એક એકદમ માઇનર ઇસ્યુ છે પણ એટલું બધું હાઈકોર્ટના મેટર
પેલું એડિશનલ એવિડન્સ
હાલો